Item number 1.
May I please your lordship, my lord. Annexed to is representation, my lord, pending before the Tahsil Baleswar, Sadar Tahsil Baleswar, my lord. Only dispose of the representation, my lord. Annexed to running page 30, my lord.
Item number 1.
May I please your lordship, my lord. Annexed to is representation, my lord, pending before the Tahsil Baleswar, Sadar Tahsil Baleswar, my lord. Only dispose of the representation, my lord. Annexed to running page 30, my lord.
The same is being repeated.
No, somewhere. No, no.
1.
May I please your lordship, my lord. Annexed to representation, my lord, pending before the Tahsil Baleswar, Sadar Tahsil Baleswar, my lord. Only dispose of the representation, my lord.
You've got some other phone open, is it?
The same is being repeated.
No, somewhere. Mr. Baji.
My lord, annexed to representation, my lord.
No. This representation has already been disposed of, or you want it to be disposed
He
of?
wants it to be disposed.
Sorry? You've got some other phone open, is it?
The same is being repeated.
No.
Open rakhichante ki?
Mr. Baji.
My lord, annexed to representation, my lord.
No. This representation has already been disposed of, or you want it to be disposed
He
of?
wants it to be disposed.
Sorry, please reconnect. I think you'll have to remove and connect again. Pass.
Item 1 passed over. Item number 2.
My lord, item number 2, state is the review petitioner. In a peculiar background, we have filed this review petition to recall the order passed by the Honorable Division Bench of this Honorable Court in 2012. The background of the case, I will quickly place before your lordship what is the background of the case. The suit land involved 19 acre 532 decimal of land within the Cuttack municipal area. This was declared to be a ceiling surplus land by the under the Urban Land Ceiling Act by the Ceiling Authority in as early as 1998. That order was challenged before the Honorable High Court, and while the matter was pending before the Honorable High Court, the Repeal Act came into force, and by virtue of that Repeal Act, the petitioner claims that I am entitled for exemption, and the Honorable Court directed that his case should be considered under the new Repeal Act and remanded the matter. Then again he filed a review petition to recall that order that was reviewed, and another writ petition was filed by WPC 13313 of 2005, a fresh writ petition stating in the review petition, and that writ petition was filed on a single date, stating inter alia that possession has not been taken over by the state government, which is essential and mandatory under section 10(6) of the ULC Act. Therefore, this land is liable to be declared as.
No, but why an IA? I don't understand. How can you file an IA? You want a review petition, right?
A review petition, my lords.
No, but this is why have you filed it as an IA?
For review of the order.
No, for review to file a review petition.
That recall, that is actually we have prayed for recall of that order. Only one thing I will appraise your lordship what has happened. This whole question before the Honorable Division Bench was that whether the possession
14, right?
Yes, whether the possession was taken over by the state government within the before the amendment.
No. Just see the prayer, sir.
Yes.
Come to IA 12, is it?
Yes, ma'am.
Admit the review petition. So why have they numbered it as IA? Then you have to explain delay in filing review. Actually, you have to file it as review along with a delay in filing review, sir.
My
You
lord,
can't entertain an IA.
review.
Your
this is
prayer
because-
says, please admit this
No,
review petition.
No, recall, the
No,
fourth line, they recall the order.
No. You have typed it as file, admit, just come to the prayer clause.
That is there,
Ah.
but the prayer is
And it
after
has to be
hearing,
a
allow
review.
the same and
It has to be
recall.
only review, sir. It has to be only review.
This, again, if it is reviewed also, this honorable court will hear the matter.
Maybe that's
But
different.
my respect, your lordship may hear me for a moment. What is the fraud behind this? They, in order to establish that possession has not been taken about, they have relied upon a letter of the government, which is at Annexure B of your
This,
lordship have a
you're-
glance.
No, you're filing it after 10 years now.
Yeah, that is there. But
No,
when
are these people still around?
all of them, they have filed contempt. And the contempt court has directed us to comply within 1 month, and it is yet to be expired. Only thing is that
Alright,
how
this
the fraud
IA
has been.
All right, this IA number 12 to 2023. You say this IA is in fact to be registered as a review petition. The registry is directed to renumber it as a review petition. Counsel for the petitioner state, review petitioner state undertakes to file an appropriate application for continuation of delay in filing the review petition before the next date.
My lord,
Say notice returnable. So notice on the so this is at first I-12. Okay, all this is in 12. This call for the records is already there.
that is already there.
IA
not
13 of 2023, since the entire record is already available in soft format, in soft copy. No orders need to be passed in this application. It is disposed of as such. In IA 14, you say the proceedings in contempt case number.
Now that contempt case is already disposed of. 1 month time is granted to us for compliance. That 1 month is going to be.
So they'll again have to file an application.
No, because I am, as per the order of the Honorable
What will we stay? There's no order.
No, the order sought to be reviewed may be kept in abeyance. That is only.
The order dated 18/10/2012.
Passed in OJC
OJC number
7386
7386 of 1999 and
And
Writ Petition
WPC
Civil 13313 of 2005 shall remain in abeyance till the next day.
obliged.
Let's start.
Just after reopening,
Yeah,
we'll take by speed post.
7 July. All right.
Item number 3.
Abeyance.
Item number 3, the same matter.
So 3, 4, everything, sir.
Item number 5.
Please, your lordship, the CMPL is for registration of the case, my lord. The case was dismissed on 25/4.
What's the main case about?
My lord, matter is relating to PIL matter, my lord. The CC road was constructed in a forested area, my lord. Some trees are cutting there. For that, I have given a representation by the Annexure 3 to the collector, my lord.
Come to Annexure 3.
My lord.
Come to Annexure 3.
Annexure 3.
Where is the acknowledgement?
Annexure 3, page 11, my lord.
Where is the acknowledgement that you have made the such representation?
My lord, date was mentioned, my lord. 20.
No. Where is the acknowledgement that the authorities, the collector has received such your representation? Or
I have not
any proof
attached
of
this, my lord.
delivery of such representation?
No points are there. There's no point. If I'll make a fresh representation, you can again file another PIL.
I'll file the fresh representation and
All
consider.
right. Counsel for the petitioner states that a fresh representation will anyway be made. In that view of the matter, no orders need be passed in this application. Dismissed.
Item number 6.
Yes, my lord. I may kindly be permitted to withdraw to avail the alternate remedy, my lord. As it is a tender matter,
What is
I need to avail alternative remedy.
Acha, counsel for the petitioner seeks leave to withdraw the present petition with liberty to avail other appropriate remedies as may be available to the petitioner according to law. Disposed of is withdrawn with liberty is paid for.
Item number 7.
My lord, may it please your lordship. My lord, grievance of the petitioner is at Annex 1 for regarding illegal settlement of a large scale of government lands in favor of opposite party numbers 4 to 9. It's pending before the collector, my lord.
When was it settled?
It was settled in 2011, my lord.
How can you come in 23? What's the explanation of the delay?
My lord, presently the petitioner found out those through the
These are
RTA
not PIL, sir. Obviously, some private litigation. It's not a PIL.
My lord, the presently found it through RTA application, my lord.
This is obviously private interest, sir. Nothing to do with public interest.
The petitioner obtained the certified copies of those settlement.
Who are you? Who's petitioner? What is the public interest element in this?
The petitioner is a resident of that revenue village, my lord.
It's not so innocent. Suddenly you can't wake up some 12 years later and say, let me throw out people.
That individually it has to be challenged. If somebody's record is not correct, that individually it has to be challenged before the appropriate
But I have also prayed for a personal hearing. If that be given, I'll produce.
These are all actually, you should be filing a civil suit. It must be time barred actually.
Thing.
What do you wish to do? We want to dismiss it.
I want to withdraw.
Council petition seeks leave to withdraw this petition. Dismiss this withdrawal. All right.
Item number 8.
8, my lord. I'm challenging the action of private opposite party 5 and 6 to encroach the land, public land, my lord.
Who are you?
I'm
When did they start encroaching?
No, and they started encroaching, my lord, from
Listen,
last
that
7
doesn't seem like a public interest litigation at all. Again,
my lord, just a minute. I would like to submit. When I was doing stamp reporting, the stamp report pointed out that as it is a public land, you should go for public.
maybe you are also encroaching. We don't know.
No, I'm not encroacher.
Yeah.
I'm just inhabitants of the land. And I'm the
When
upright
did
party, my lord.
They started doing stamp vending day before yesterday. When did they start?
I just filed 5 means 5th of this month. I filed this and I filed doing stamp reporting. It was pointed by the stamp reporter, my lord. That
I don't know whether you understood the question. I'll ask.
then your lordship may assign before appropriate bench, my lord.
What?
As it is a OPL.
Suddenly this stop being a PIL. If you ask 2 questions, it's not a PIL.
It's not.
Then it becomes single judge matter.
My fault, my lord. As I was filing under OPL, but
This is nothing to do with writ petition at all. If you ask me, it's obviously some private interest litigation.
then, my lord.
We should discourage all this.
Then I'm
misusing.
permitted
The
to
whole
withdraw.
process is getting misused. People forget CPC for everything under the sun representation. And then get an order in the writ, then again contempt, same route. No court fee. This is what, 6.5 rupees, right?
Sorry, my lord.
Court fee for this is 6.5 rupees.
No, not at all, my lord.
Not even 6.5 rupees. You have not paid even that
No,
much.
Not. I just wanted to submit that when I was doing, I was filing under OPL, but as it is pointed out that it's public land, that it should be PIL, my lord. And court.
We are not entertaining it, madam. Sorry.
Then I may be permitted to withdraw.
Counsel for the petitioner seeks leave to withdraw the petition. Dismiss this withdraw.
Item number 9.
None appears dismissed.
Item number 10.
None appears dismissed.
Item number 11.
Item 11 was double filing that I want to withdraw that.
It's a case of double filing. Dismiss is withdrawn. This writ petition is go back.
Yes,
nothing, no?
that second writ appeal is there, 410/2020. That writ petition will
Go with that. Okay.
that
This
matter
writ petition be tagged with WA 410 of 2020.
That was disposed of and remanded to honorable single judge.
Okay. So this writ petition, no orders need to be passed. Just send it back to be placed before the roster bench. Single judge.
Item number 12.
The impugned order is page 47, my lord. Now, the only prayer, my lord, of the petitioner that the time period given by the learned, the honorable single bench, my lord, may be extended to further 2 weeks and the representation will be continued.
Why? Nothing. It's a 2021 matter.
The only direction is there to consider the representation.
Yeah. The direction issued by the learned single judge being innocuous does not call for any interference. Right.
Item number 13.
Item 13, let's see, just a glance, page 29, annexure 3. The order impugned for lordship is also impugned in another writ appeal. And here that is the interim order is there. Same matters. 7 petitioners there. Another petition coming for lordship.
All right. Along with, when is that coming up? 7/38 of 2020. You know, you can go and find out from the net.
Actually, I
Suppose you want to find out what has happened in Writ Appeal 738 of
That is-
2020.
that is pending.
Huh?
Pending.
Sorry?
Pending, Millard. Pending.
When did you go and find out?
I don't follow it.
You don't know.
No, I don't follow. What's the supposing I don't follow?
Seven 30 is already disposed of as the website shows.
738.
Which is why I'm asking you, are you aware as a lawyer that in our website, suppose you want to know the status of a matter, you can go and find out. Are you aware that you can go and find out?
Actually, I am not.
Not aware. Not necessary.
I am not necessary, but I am not accustomed to these processes.
Not accustomed.
Yes.
I see. You
Well,
need special coaching class
No, that the coaching class is required.
required.
Yes.
All right.
That is required.
Mr. Mohanty, where is he? Is he sitting there? No.
Actually, I am not accustomed to these seminars.
Please ask Mr. Dharnidhar Nayak. You know who Mr. Dharnidhar Nayak is?
Yes.
Who is he?
He is our president.
Very good. Please ask him to arrange for a coaching class for the entire bar on using our website. You get very valuable information.
Yes, absolutely.
So one such valuable information we're just passing on to you. Okay. You noticed how in
Yes. If that is disposal or second disposal.
no. Did you notice how he got the order in 2 minutes?
All right, I do.
You want to get coached by him?
Yes, obviously, if necessary, no problem.
If necessary.
Yes.
You don't find it necessary.
No, yes, I feel it is necessary.
Sir, it's okay to tell us thank you for giving you a copy of this order.
Thank you, sir.
Most welcome, sir. Counsel for the appellant states that against the very same impugned order, WA 738 of 2020 was filed.
Oh, Lordship.
Paragraph, this court finds that the said writ appeal has already been disposed of by an order dated
31/1/2023.
31/1/2023. The present writ appeal is also disposed of in the same terms. All right.
Item number 14.
14, 15, 16, 17, special list. That's sort of product.
Same. Sartapad.
Item number 18.
May I please, your lordship? This is a covered matter. The settlement of tenement in favor of the respondent, BMC matter.
Same order.
19, 20, 21, 22.
All
Same
right.
matter. Obliged.
Item 23.
None appears dismissed.
Item number 24.
24 minutes special list Sattapad case.
Sartapad.
May I beg pardon, your lordship? May I beg pardon, your lordship? I am in BC.
You're not visible, madam.
Your lordship, there is some network problem. May I beg pardon, your lordship? I am in BC. Item number 23. Your lordship, on behalf of Deepali Mahapatra, may kindly one pass over.
All right, pass over.
Obliged, your lordship.
Item 25.
Permit to withdraw my.
All right. Dismissed as withdrawn. All right.
Item 26.
Pardon my lord, inadvertently in this case the noting has been made. I have not filed the limitation petition here, though I have filed the limitation petition, but inadvertently the subject matter of that the first page, I number 1773 of 2021, interlocutory application number. Here the subject.
What is the delay?
delay 1209 days.
Sorry, sir.
1209 days delay.
So tell us what happened.
Due to severe diabetic problem as well as
Diabetic problem.
Yes,
This is a new excuse, sir.
my lord.
Every time you're getting new varieties of excuse. So if you have diabetes, you don't have to file
And
appeals
also
in
high
time
blood pressure. He could not come to the office
because of diabetes.
high diabetes.
You are giving many ideas, fresh ideas to so many lawyers. Diabetes doesn't stop anything. So you have to, in fact, no medical advice, no, on diabetes. You have to be.
Yes.
Diabetes means you should be really active. That's the medical advice.
The petitioner had explained me is such type of
You don't accept it. You please tell him these judges are very unreasonable, sir. They will not accept this kind of explanation. Give me some other good explanation. No good explanation.
Further, also due to pandemic situation of COVID.
Pandemic and all. This is 2017.
Yes, 17.
Unless you had great foresight for 3 years later, what will happen? It's very difficult.
High blood pressure.
So second also bad excuse. Now come up with some good excuse, sir. We are waiting to help you. You're not giving us chance.
As your lordship.
What?
My lord.
Over. All right. There's an inordinate delay
1395
of 1395 days, which has not been adequately explained by the appellant. Full stop. Consequently, the court is not satisfied that any ground has been made out for condemning the extraordinary delay. The IA is dismissed. Consequently, the writ appeal is dismissed.
Item 27.
My lord. Here, my lord, this appeal has been preferred against the order of Honorable Single Bench, my lord, that the delay for which I have filed a IA number 2011 of 2021.
13 days. All right. 30. All right. What's the main matter about?
My lord. My lord, in this writ appeal, my lord, item 27. Challenging the order of Honorable Single Bench, my lord. Here, my lord, I have filed the one miscase IA 2011 of 2021 for limitation, my lord.
Sir, that is over. Delays condoned. Come to the main matter. Tell us what is the main matter about.
My lord, so far the main matter, my lord, is concerned, my lord. I am not prepared by time to.
We are prepared, sir.
Tomorrow, my lord.
No, sir. We are prepared. Delay is not such a complicated thing, no? Very simple.
Delay, therefore, I think, my lord.
You know how much listing a matter in the High Court, how much does it cost? Are you aware? No. Every matter which is listed, how much does it cost? Do you know? Not aware. But we both are aware.
Sorry for that, my lord.
No, you don't have to be sorry. You must be happy that your writ appeal of 2021 finally got listed, even without your asking.
No, my lord, this writ application.
Miraculously, it got listed.
My lord, I oblige for that, my lord.
So make best use of opportunity. You never know how much, when will this opportunity come?
My lord, I pray, my lord, honorable, pray, my lord, one opportunity, one time, my lord, one day, my lord.
No, we'll give you opportunity of how many? 2 hours we'll give you. We'll pass it over. How big is this paper book? How many pages?
That, my lord's judgment is a big one, my lords.
Our copy says 38 pages. Even if you read it very slowly, sir. 38 pages. You're a seasoned lawyer. Even if you read it very slowly, 10 minutes, it will be all over. We'll pass it over. You read it and come back. Pass over.
Item number 28.
At 20, 29, 30 double filing withdraw.
Sarita Parada.
Withdraw.
Withdraw. Okay. With review.
No, my lord, this is double filing.
Double filing.
My lord.
All right.
Item 31.
31 is also not Sarita Parada. Specialist is there today.
All right.
My lord, this I am there for 31 and 33. I have a submission because all these cases is stated that is Sarat Parida. Actually, Sarat Parida decided the cases of an institution which is coming under the direct payment. But there are cases I found So there are the block grant institution. That is why probably there is a confusion.
Yes.
Can it be segregated so that it can be disposed of? Because everybody is saying Sarat Pada, because Sarat Pada was argued by me. And that has gone to Supreme Court. But
See, they didn't know how to get you here. That's why they kept saying this.
no.
Now that you have come, you will clarify everything.
Because there are bunch of cases that the difficulty will face.
Bunch is such an understatement. This bunch has got some 900 matters or 1,000?
700 something, I think.
No.
600.
665.
Because some school matters are there, block grant institution there.
Yeah, so far as the school matters are concerned, I don't know what is the number. I am appearing in some cases, but I'll concede today because your Lordship have already referred the matter to the single judge again. My cases are concerned, I'll concede.
Whoever is going to be the poor single judge, one fine day he'll have some 600 cases.
In fact, I have prepared and I have come to your Lordship, so that order also, the same order may be passed because the adjudication.
So what we'll do is, subject to what you say, we'll stagger it, no? Because it will be too much for any single judge to handle on a single day.
No, once your Lordship, so far the schools matter are concerned, totally different from the college matter. Even if 4 or 5 matters, same, exactly same. If it will be decided, other cases will be covered by that.
Covered.
And this college matter also, there are.
See, if you undertake that you will file one comprehensive affidavit.
In fact, they have already filed a counter to that case, which has already been, Lordship, look to your Lordship's order. Your Lordship have given the time limit. Counter will be filed within this time, rejoinder will be filed within this time. And that has been done. And the pleadings are about to be completed because rejoinder has been filed. That has been posted in the report by Justice Mishra's courts.
3 types of cases there. School and 2 types of cases in college. College, 1 block grant colleges are there, and 1 aided college block grant post. So there are 3 types of cases. You can file 3 counters in 3 types of cases.
That will get.
And out of that 660 or 65 matters,
these 3 categories.
What has happened, my lord? In 4 to 7 cases, counter has been filed, and that has been disposed of. But our stand has not been taken into action. So all these matters can be disposed of. I have given that copy. I have given
this Banamali swine.
There's a remand order. He has given me one.
All these matters can be disposed of if your Lordship will grant us some time that we can file counter. If that counter has been filed in some cases, that has been disposed of.
May segregate so far as school case are concerned.
Segregated these 3 type of that much my lord may take.
In this entire batch, there are 3 broad types of cases. 1 pertaining to schools. 1 batch pertaining to schools.
Yes, ma'am.
And 2 batches pertaining to colleges.
1 is direct payment, 1 is block grant.
Yes, ma'am. 1 is direct payment.
College cases, 1 batch pertains to direct payment and the other to block grant payments.
Yes.
Paragraph. It is agreed by both counsel on both sides that an order similar to the one dated 24th April 2023 in writ appeal number 366 of 2021.
That is in respect of college.
Bracket State of Odisha versus Banamali swine and others, bracket and batch, may be passed in respect of the 2 batches of matters pertaining to colleges.
Yes.
Paragraph. In other words, in all these 2 in the writ appeals in these 2 batches, the corresponding orders under appeal in the writ petitions were passed by the single judge on the very first date of listing of the writ petitions. Full stop. Although in some of the writ petitions, counter affidavits may have been filed by the appellant state, that was not discussed in the impugned order of the learned single judge. Full stop. In many others, no counter affidavit had even been filed. Paragraph. In line with the order passed with this court on 24th April 2023 in the aforementioned matter, bracket State of Odisha versus Banamali swine, this court, while setting aside the impugned orders of the learned single judge, remands the writ petitions, corresponding writ petitions. Then you say, in these 2 batches of writ appeals to the file of the learned single judge in the roster bench. Full stop. The court is informed that 1 batch of such writ petitions are already listed before.
No, so far the school matter is concerned.
I see.
School matter is concerned.
All right. Since this is likely to be a large batch, the court directs that the block grant matter be listed before the learned single judge on 18 September 2023. Wherever a counter affidavit has not been filed, it will be filed in the concerned writ petition on or before 4th September 2023, and the rejoinder, if any, thereto on or before 18 September 2023. It is made clear no further time will be granted for the above purposes. The learned single judge will proceed to hear with the writ petitions on merits and endeavor to dispose them of as expeditiously as possible till such time the status quo shall be maintained. Paragraph. As far as the direct payment cases are concerned, the payment pertaining to colleges is concerned, the corresponding writ petitions will be listed before the learned single judge on 25th September 2023, with the state filing its reply to such of those writ petitions where it's not already been filed on or before 18 September, and the rejoinders thereto, if any, on or before 25th September, with no further time being granted for that purpose. Again, here, the learned single judge will proceed to hear the writ petitions on merits and dispose them of as expeditiously. Paragraph. As far as the school matters are concerned, that is writ appeal numbers dash
383 of 2020.
batch
And batch.
The writ petition, while setting aside the impugned order of the learned single judge, the court directs that these writ petitions be listed. When has it listed, that other one?
It was listed on last Monday, on 29/3/2023.
And no date has been given.
It was listed for court number 11. It has been, counter has been filed, counter has also I have got it. I have prepared the rejoinder will be filed. You will also fix up any date, that is WPC 19636 of 2019.
19636 of 2019.
19636 of 2019.
On 16th October. The replies, if any, by the state
already filed in that case.
No, in that case, in other cases,
if required to be filed, shall be filed not later than 3rd October, and the rejoinder thereto on or before 16th October. No further time will be granted for that purpose. These writ petitions, along with petition number?
Along with writ petition number 19636 of 2019.
19636 of 2019 shall be disposed of as expeditious as possible until such time status quo shall be maintained.
Item number 4849 and the back. Please tell me. Only one thing I don't.
May some modification may. Madam, kindly keep this gratified case, college cases fast thereafter block grant. For us, my lord, it will be better. My lord, have fixed block grant to 18/9 and gratified case 25/9.
All right. Grant make it 18.
Yes.
And block grant make it
25/9. My lord have said. Just reverse. Yes.
All right. All right. The entire batch. So you'll have to give us those.
So far the schools matters are concerned, can you also
give it to us in a day or two? No problem.
Yes, I can give it all.
Segregate.
I
think both sides you can help us with that.
Yes. LRC will grant me 2 days.
2 days, all right.
And it's
segregating the batches.
Yes.
All right.
2 days. May I request, so far the schools matters are concerned, can you also little bit early?
We'll be pressurizing them, that's all. As it is, they won't get time.
What will be lesson also for their concern?
Let it go.
All right. All right.
This 31/33, sir.
Yeah. Sure. We'll do it.
31,
now that this is over and
this 31/33, my lord, sir.
Yes.
I
31.
think this will also cover the item number 1 in the
Special list.
One in the specialist. Yeah. That whole thing.
Only
Correct.
segregation of two.
As well as 48 and 49, your lordship.
48, 49.
My lordship.
All right.
Item 32.
32 short 32, 33, 34.
Item
Sorry,
35.
I'm sorry, my lords, for interrupting that item number 1 in the special.
I know that some problem was there.
Yes, my lord. The fourth sub-item is completely different. That's regarding the PF matter. So that
one
can
matter
be
is not Sartapada matter that has been that
by wrongly it has been
Wrongly-
listed. So your lordships can either fix up a date or take a
All
whatever.
right. In that matter, you see list of
that one matter.
My lord, another matter, my lord.
1 minute, sir. 1 minute.
That is Odisha
Power Generation
W78, my lord.
WA 78 of
78 of 2020.
2020 list of 25th July.
My lord, writ appeal in this list, writ appeal 877/2022, that is relating to Anganwadi matter, may be taken any authority, my lord.
877 of 22.
22.
What matter is it?
That is in item 1, that is in added in item 1.
No. What is it about?
That is Anganwadi.
Anganwadi worker.
Yes.
Acha, acha. 877 of 22. You see list on 28th August. Sir.
Your lordship,
That I am for the respondent of 87720.
your lordship,
Separate he gala seta.
your lordship, rate appeal number 484 of 2021. I am for the respondent in the special list. Your lordship, that matter may be segregated. That is the matter relating to de novo inquiry of the CISF officer.
I see. 484 of 2021.
Yes, your lordship.
List on
In the special.
31st August.
Oblige, your lordship.
Similarly, my lord, in the same item number 1 of the special list, appeal number 117 of 22, my lord. That is a different matter. It relates to notional increment, my lord. That has come.
117 of 2022. List on 12th September.
Item number 35. Item 35. Sir.
None of this.
Item number 36.
I may please your lordship. I'm on virtual mode.
Yes.
Item number 36.
Yes.
Let's see, kindly see my date chart, my lord. My case before lordship is the respondent number 6 has filed more than 5 writ applications, suppressing all the facts from 2016, and ultimately after 8 years, this single judge has directed to consider my representation. On each occasion, I have filed my counter in every writ application. Many writ application withdrawn without liberty. Again, my lord, filed, suppressing the fact that previous writ application have been filed. And 5 times I have filed my counter. All the pleadings were completed, but the single judge again directed to reconsider the representation. Suppose the representation be rejected, again I have to come before your lordship, my lord, as a party. That is my grievance. Now, say, look at the date chart. I feel convinced. Appendix B, my lord. Date chart. Selection was completed in 2016. Then, my lord,
But the operative portion of the order of the single judge,
yes, ma'am,
is to only direct opposite party number 2 to take a decision on the grievance raised with the petitioner.
Bow down, my lord. That is my grievance. My grievance is logically turned to Appendix B, my lord, the date chart. Second page.
Yes.
The respondent number 6 challenged the said merit list by filing WPC number such and such, my lord. Then, my lord, the counter and other things are filed.
Your Prashant is fine, is it?
Yes, my lord.
All right.
My concern is that 5 times I have appeared in different application on the same cell prayer filed by the respondent 6. After 8 years, now the court has directed to consider representation. Suppose representation will be allowed or dismissed. Again, I will be subject to court and I will be a party for lordship.
All right.
It is a res judicata, clearly res judicata.
Yeah. Counsel appellant states that although the impugned order might seem innocuous, impugned order requiring the respondent number
6.
No. Respondent number. No, who has to consider the Director Visimar?
Respondent 2, my lord.
OPSC.
Well, yes.
OPSC.
Has been asked to reconsider the representation of respondent number 6, there has been a suppression of material facts by respondent number 6 concerning the previous litigation brought by him on more than one occasion. And therefore that this might unnecessarily create difficulties for the present appellant. It's a notice returnable 12 September. Notice is accepted by him for respondent number 1,
4, 5.
1, 4, and 5. Notice the remaining respondents by speed post. Tracking report will be placed on record. If not already considered, if not already implemented, the impugned order shall stay in abeyance till the next day.
Highly obliged.
Item number 37.
37, Your Lordships. At the threshold, I shall admit that, Your Lordships, this appellant for whom I'm appearing was OP number 9 before the single judge. She did not appear. And therefore, Your Lordships, I'll restrict my argument to whatever was already available on record. This one thing, had the single judge taken into consideration, probably the judgment would not have been the way it is. Your Lordships, the matter actually arises out of an OPSC selection where, Your Lordships, it's for various departments. We are concerned only with economics. So, Your Lordship, what happens is for various universities, a common recruitment is held. But each university, again, is a cadre. They don't have a common cadre. Each university, separate cadre. And they did say what are the vacancy positions in each university and the reserve points also. So, Your Lordships, I stood 5th in that merit. And the petitioner was 6th. The petitioner was shown against...
Who's the reserved category? Who's the unreserved?
No, Your Lordships, actually, both of us are general category candidates.
All right.
But she was shown against the woman quota for the general category. And I was shown against just the general category. So after that merit list came out, OPSC and Your Lordships, we had an option that we had to give 5 options wherever we wanted to be selected to. So all of us had given option with the in person to the advertisement. When the select list came out, OPSC also stated to the government that as far as allotment is concerned, while making allotment, if a particular candidate on her merit is in an unreserved vacancy, she shall have the option to go up in her choice. Even if while going up, even if that post has been shown in any university to be a woman quota post. That's what they stated. Accordingly, government gave me Revencha and gave petitioner Berhampur University. And thereafter, this matter was filed. Those guidelines of the OPSC were not taken into consideration. And the court stated that I find no reason as to why this exchange happened. Your Lordship, just to make the matter clear, may I take Your Lordships to page number 56.
So both of you are resident of obviously Bhubaneswar or someplace.
Must be, Your Lordship. That's all the fight. Personally, do not agree to it. 56. Your Lordships, my name finds place at serial number 5.
And her name?
6.
Oh, just one after.
Yes, Your Lordships. Of course, Your Lordships, I was looking at this is a horizontal reservation. My understanding says in horizontal reservation, what normally happens, suppose there is 3 seats. So if there are already 3 women, no more reservation should actually be shown. But I don't think why state does not do that in this case. So because if I'm already there, there was no more requirement. But if I look at the things from that point of view also, I could have taken the URW post. But Your Lordship, she was 6th. She was allotted Barampur, which is also shown. Before that, Your Lordship, look at page 57, where OPSC gave the directions. Page 57. I'll just place that, Your Lordships.
Yes.
I'll place both the horizontal vertical. If a candidate under reserve category has been placed against UR vacancy on merit, he or she can avail a service cadre higher choice of his or her preference, had he or she been adjusted either against UR or reserve vacancies. In other words, such candidate have the option of both being under UR category as well as reserve category as far as availing of his or her higher choice of service or cadre is concerned. Same thing I applied for horizontal, it's written below. Then, Your Lordships, comes the government's allotment letter. Your Lordship's specific page will be page 63.
Yes.
Your Lordship, page 63, 5th. But I am here, Your Lordships. I've been shown UR because my merit list was showing UR. But while allotting me, they gave me Ravenshire University because Ravenshire University was my second preference. But at that time, Ravenshire University...
But you're shown as URW.
Yes, because that post was URW. That option allowed us to go up. While going up, if it was URW, I can avail that. So basically what it says that, because Your Lordship, the whole concept of option is the person who's higher up in the merit, his or her preference is given, his or her option is given preference over somebody who's lower in merit. So I was higher up in merit. So that's why, and so therefore you're the first.
I thought the normal thing was if you're anyway coming in merit, you lose your option for being treated as any special category.
Yes, Your Lordship. That's what the government, OPSC also stated, and government did that. And even in that page also, that's what written on the first paragraph. That's exactly what is written. And this is how they have done it. But anyways, matter was filed before the single bench. At that time, I was in Ahmedabad working. For some reason, I did not come and participated. Thought that government would take care of my side. But the order has come out and these things have not been taken into consideration. May I take Your Lordship to the impugn order?
So you're still interested in the job?
Yes. I'm still now working in Ravenshire. Right now, I got posted in Ravenshire. And she's in Barampur.
What is the date of the impugn order?
Your Lordship, the date of the impugn order is 24/3/2023, not given effect to.
All right. You see, notice returnable. We'll have to have it after the vacation. So you say 22nd June? 22nd June.
Lordships.
There shall be a stay of the impugn order till then.
Item 38.
So he accepts notice. 1 minute. Some place to accept notice of the state. 1, is it?
Yes. Universities are there and private responses are there.
He accepts only for 1. Not even OPSC.
No, madam. They have their own pen.
Remaining, you see, were registered speed post. Or not the pro forma ones, or?
That's because petitioner had made all of them parties, so I insisted.
You have no option. Yeah.
So also respond number 25. 25 also would accept.
Yeah, everybody. Oh, you're accepting but 25.
Yes. 25, because I don't know why, but
all right, 1 and 25 you accept. Notice to the remaining. Which one? This matter. Previous talk is just cancelled. Right.
Item number 38.
Wait, please, Your Lordship. But if Your Lordship looks at the decision of the Honorable Court at page 27, the initial order that was passed, my case is that it has not been complied with the letter and spirit with regard to the direction to comply. Page 27, Annexure 5. It is order dated 22/10/1998. But it says the Ishaq Behra, Collector Cuttack, and Satyajit Mahanti, Superintendent Police Cuttack, are present in person. We have perused the joint report submitted by them. We are unable to pass any order as it concerns maintenance and law and order. However, both the above officers, or there's a specific direction, have made a statement that another attempt will be made to resolve the issue. For that the purpose, a meeting will be held in this evening. The collector has also stated that the president and secretary of the state Puja committee of Chandni Chowk and Mahmadiya Bazaar and the secretary of the peace committee of Sheikh Bazaar will be invited to the meeting. We hope and trust the matter will be resolved in the evening.
Yes.
But this has not been complied because this more than 100 years of tradition is going on between the two puja committees to fix up the area which they want to go with the puja procession. Because a lot of difficulties are there in Cuttack, in different sai and other things are there. Sentiment is also involved. But this dispute, many a times actually they called meeting and it was held. 87, there was a decision that was stayed by the collector himself, because collector says that decision is not to happen. Then, if you'll also kindly turn to page 29, the counter affidavit they have filed E by 2. E by 2. It is page 56, I think, in your Lordship brief.
Yes, 56, correct.
22/8/2017, it also says that heard the counsel of the petitioner, the additional standing counsel, the limited grievance of the petitioner that as per the proceeding dated 22/12/87, there has been settlement between two puja committees in presence of district magistrate and collector, but the same is not implemented. Therefore, representation has been made. But this writ has been filed without disclosing the fact that collector has stayed the decision. Collector has himself stayed it. That also the documents are there. But let the learned district magistrate and collector Cuttack take a decision after affording opportunity of hearing to both the parties. Not got that. Then a contempt application was filed. So kindly turn to page 30, order dated 9/1/2019.
Yes.
At page 30, Malad. The direction was to take a decision within a particular period, Malad, within 3 months. But at this stage, what happened? And then inquiry was conducted by the previous ADM who has been transferred with the DCP. Now the present collector calls for a meeting, and without verification, he immediately passes an order reiterating that 87 decision. Our submission is that let opportunity given as per the first order and subsequent order, let a joint meeting be held, let a decision be taken by the collector and district magistrate afresh. If your lordship looks at the decision that has been taken, that itself is contrary to what is the respective submission of the parties. Kindly turn to the order that has been passed.
My lord, I am for the opinion number 3, my lord. I am submitting that a joint decision was taken by the collector and DCP. I am submitting before your lordship a joint decision was taken on dated 30/4/2019, my lord.
And page 31, my lord. Page 31, if your lordship looks at.
I have submitted the English translated copy of that decision, which is passed in Notice Annexure A by 4. In that decision, my lord, it is. I'm just reading the translated copy of that order. That joint decision of collector and deputy police commissioner with regard to boundary dispute of Chandni Chowk Puja Committee and Mahmadiya Bazaar Puja Committee, as per content case number 1280 of 2018 by the Honorable High Court of Orissa. As per the High Court contempt number 1280 of 2018, with regard to boundary dispute of Chandni Chowk Puja Committee and Mahmadiya Bazaar Puja Committee, Mr. Arvind Agrawal, IAS and Deputy Police Commissioner Cuttack, Mr. Akhleshwar Singh, inspected the joint spot on 2/3/19 and the decision taken accordingly. 1. From Chandni Chowk through Mahmadiya Bazaar main road at Prajatantra Prachar Samiti main gate, on the same road in the left side boundary Prajatantra Prachar Samiti, and in the right side of the gate Prajatantra Prachar Samiti where the municipality drain was situated, was declared as a middle point of Chandni Chowk and South Mahmadiya Bazaar. Second, from the Prajatantra Prachar Samiti gate
where municipality drain was situated 20 feet from both the sides, left and right, was declared as no man's land. 3. At the time, 20 feet. And at the time of different festivals, if any puja committee desires to construct gate, they can construct gate and light by leaving 20 feet from the middle point towards their own sahi. That decision was passed by, that joint decision was passed. I have submitted a translated copy.
So here the question is, the short point I'm raising is joint inspection that has not been done. The order has been passed jointly as per the contempt petition was filed. They immediately passed an order. On the basis of the previous inquiry, no report is available. So let them have a fresh look into the matter, and they will be given opportunity. Let the government take a decision, collector and DCP.
What do you say?
My lord.
He says just one more opportunity, fresh opportunity to be granted.
There was already an investigation inquiry, and this is the report. And that concept of no man's land, that is everywhere in Cuttack city.
No, we also want no man's land should be there. Sir, with due respect to my friend, Manad, but here what has happened, Your Lordship, I think Your Lordship must have gone through that Chandin Chowk to Cuttack Chandi Road.
Correct.
So there is a masjid after the Prajatantra Press.
Right.
We want the Prajatantra Press gate to the masjid. That was the previous practice. That area should be kept as no man's land. So that is about 100 feet. What they have done, Muhammadiyah Bazar will have his gate within 20 feet from Prajatantra gate, that is covering that masjid area, which we don't want. With reason being, that's a Muslim dominated area, that 100 feet should be kept as no man's land. We want that.
And I think in that report, that matter has also been taken care of.
No, that has not been taken care of. That is exactly the point. Because no joint inspection by the collector, present collector. It was by the ADM who has been transferred. So now they let the collector do it, sir. We'll cooperate, both the parties will cooperate. A fresh inquiry should be held.
Because all parties agree that a fresh inquiry can be conducted by the collector.
Right.
After the departure of the previous incumbent.
Right.
To stop, the appellants will be happy if a hearing is given to them and a decision taken in a time-bound manner. Correct?
And that collector
and DCP.
And DCP or their representative. Because yes, ADM can be deputed for the purpose. The ACP
yes, ADM can be deputed.
That is what if your lordship will say only collector, then
collector or anyone authorized by him.
Yes, authorized.
By
authorized officer.
Noticing both the puja committees, should be noticed for inquiry.
Yeah. Additionally, notice will go to both the puja committees.
Right.
That is the
of
Muhammadiyah Bazar Puja Committee and Chandin Chowk
Puja
Committee. Muhammadiyah Bazar Puja Committee and the Chandni Chowk Puja Committee.
4. OP number 4, Manad.
Bracket.
And let a decision be taken within.
No, that time bound your lordship may not impose because it's a very difficult matter. My learned senior knows in his side also this type of dispute is going on.
So it is within a particular time. Let him take any time, 4 months, 3 months before the puja.
And the collector may take the assistance of the police department.
Yes, yes.
The date of hearing be intimated to the parties at least 1 week in advance.
And that interim order is there, that should continue till then.
Yeah.
All this should happen before the puja. That is the objective.
List on.
The lordship may dispose it of why it will be kept pending. They will submit the report. Then if they are agreed by that letter, they will come up with a press writ petition.
Right.
Yes.
And prepare a report and furnish it to the parties not later than 1st September.
But the decision they have taken earlier should not be implemented.
No, that
has not to be implemented.
That has not been implemented. Then why this? Because there is no such interim prayer.
Stay order previously.
No, stay order may not be there because if once your lordship is passing an order, it will automatically supersede the earlier report.
Yeah, that's why it should not be implemented till that decision is taken.
Now that is going on, then it will again disrupt.
So it has not been going on, sir.
Yes, it is going on. It is going on. We will take a fresh decision after investigation, after due investigation, and whatever your lordship may say, status quo will continue.
Yes.
Till then.
Yes. Yes.
Or yes.
Till then, status quo shall continue. The court clarifies it has not expressed any view on merits.
Right.
Yes.
Petition is disposed of.
Item number 39.
Nine,
my lord. This matter related to Sisu 1. Lordship, kindly see order number 39. On 9 July 2022, Mr. L. Samantara Leonard, additional government advocate, had undertaken that report submitted by the Advocates Committee would be examined and corrective action would be taken. Now, till then, they filed an affidavit in respect of rest shed only. And we submitted a report on 19/7/2022. To that effect, they have not mentioned anything in the affidavit.
No,
and surprisingly,
we have filed the affidavit. We have filed the affidavit on
only
1st May.
Isn't the building close to completion?
It was by submitted, my lords. On November 2021, when committee visited the Sisu 1, while Leonard Friend also part of the committee, Mr. Das is there. The site in charge and the engineer stated that it will be completed by the March 2022. And surprisingly, they also stated that there is no problem in the fund. I am thankful to the state government. They provide sufficiently fund to the building. But till then, more than 1 year has been passed. In the meantime, they undertake to complete by March 2022. More than 1 year has been passed in the meantime, and there is no problem for fund, at least, my lord. They have stated before the committee, and my learned friend is also present in court, that there is no problem to fund and they will complete it and hand over by March 2022. And now more than 1 year has been passed in the meantime, nothing has been done. And as far as the order number 39 is concerned, they have filed an affidavit only in respect of rest shed only. Number of irregularities we have mentioned in our report dated 19/7/2022, but they have not mentioned anything in their affidavit. Only in respect of rest shed only.
No, so what do you want? In the sense,
he is saying that nothing has been done.
No, I'm not saying. I'm not saying that nothing has been done.
Multi-story buildings are standing and
visible. I think that is.
I am not saying like this, my lord.
That you have said now.
As they undertake to complete by March 2022.
There
but more than 1 year has been passed in the meantime, and there is no problem in respect of fund, at least. That is my submission. And in our report, we have also submitted some work has been done. Not that I am submitting that no, nothing has been done. Not like that. As far as the building is concerned and our report is concerned, nothing has been mentioned in the affidavit. That is my submission. I have not mentioned that nothing has been done.
May I pray, my lord? I have got some submission to be made in this case.
Yes.
I am the advocate for Maitri Sansad, my lord. This matter appears today's list as per order number 40, my lord, dated 5th April 2023. I would like to place the said order. This matter is listed as per this order. As a last chance, time is granted to Mr. Devakanta Mahanti, learned additional government advocate, appearing for the state opposite party, to file an affidavit in compliance with the order dated 19th July 2022. The affidavit we filed on or before 1st May 2023. Though they have filed an affidavit on 1st May 2023, but they have not complied. As would be evident from their affidavit, paragraph 4 and 5, my lord. That affidavit finds place at flag 40 of your lordship brief. I would like to place flag 40, my lord, paragraph 4 and 5. 4 and 5, they have not given any reply to the order dated 19th July. They have only said regarding the construction of shed, and that too, the construction of shed has not been completed. It will be completed soon.
No, are you opposing his prayer?
My lord.
Are you opposing his prayer? Are you opposing his prayer?
No, man, I am not opposing the prayer. My submission before your lordship is that they have to comply the order dated 19th July. The advocates committee report will be complied. Already, my lord, 10 months has already been passed in the meanwhile. Let them comply, my lord.
Yes, what do you say?
My lord, the next matter 9504, my lord. 9504, my lord. In this matter, they have filed an affidavit, but without answering to the
advocate committee
prayer person, my lord. They have not answered it. For example, my lord, they are sharing the beds to 4 or 5 patients in one bed, which is definitely detrimental to the general health care, my lord. But they have not answered to it. Similarly, my lord, in SCB Medical College, there is no user fees collected for treatment at outdoor or indoor. But here, for the pediatric patients, they are collecting the user fees for these babies. That is a little bit peculiar, my lord. And the Sishu Bhavan is an annex of SCB Medical College. There it has not been collected. Here it is being collected.
What is the time estimate when it will be completed?
I think it must be in the fag end. But if your lordship wants to know,
some definite date has to be given.
Yes. Your lordship may direct, I will file affidavit.
And counter affidavit is being filed today.
19/7/2022.
Actually, this is a rejoinder affidavit. You say counter by the petitioner.
Only in respect to my state.
How can you call this counter, sir? This is petitioner's affidavit. An affidavit has been filed by the petitioner today in response to the affidavit dated 1st May 2023 filed by the superintendent of the Sishu Bhavan, in which inter alia it is stated that there is no progress of work as far as the new building for Sishu Bhavan that is being constructed. Further, it's pointed out that the report submitted by the Advocates Committee has also not been responded to. Paragraph. Mr. D.K. Mahanti states that he needs some time for instructions and, if necessary, file a further affidavit on the above two aspects. To stop that, affidavit will also indicate the definite timeline within which the construction will be completed.
Yes.
The affidavit will be filed before the next date. 23rd June.
Oh, bless.
23rd June.
Not the petition affidavit filed by the petitioner.
No, that's a Friday, sir. Sorry. 28th June.
8th June.
What is that?
28th June.
No, okay.
But affidavit ta deleni sir. Na.
Receipt on receipt nothing file कर भी report वीडियो के अंदर document. हमें copy कोटे दे दो.
Get chance on 4th July. 4th July.
My lord, I have got some submission to be made if your lordship permits only. Sishu Bhavan is facing two major problems, my lord.
Flooding.
That is, one problem is that water logging, my lord. The new building which has been constructed now, which is under construction, there is every possibility that rainwater will be enter into the new building, only because there is a report, inspection report of a retired superintendent engineer, PWD, who has said the plinth level is very low, my lord, in comparison. That copy I have also, my lord, submitted. And that there is another problem which Sishu Bhavan is facing, my lord, fire devastation. There is no fire safety arrangement. No fire safety certificate has been obtained by the Sishu Bhavan. At any time, any time, there will be a fire devastation. In meanwhile, my lord, 5 times there is a fire devastation. If they will not take care of the life and property of the pediatric patient and the attendant, will be in difficulty, my lord. For that reason, I have taken some time to submit before your lordship that the government should be directed to take immediate steps regarding fire devastation as well as water logging. But for the water logging, my lord, we have given an inspection report of the retired superintendent engineer who says there is every possibility that rainwater will enter into the 6+G building, my lord. If that will happen, then what will happen? Huge amount has been spent with water logging and there will be a fire devastation. What will be the fate of the pediatric patient? So my submission before your lordship should be taken into consideration and direction may be issued.
All right. We listed in the next date. All right.
Item number 40.
Oblige.
My lord, no instruction.
No instructions is missed.
Item 41.
Ah. 41 May, please, Your Lordship. Lordship, I filed an IA lately for intervention and impletion of parties that are different petitioner who are interested in this matter, because this is a PIL wherein we are challenging that the illegal dumping in the Pokhri Anand Bihar Pokhri Put area, my lords. If Your Lordship may kindly give me some time.
Illegal dumping means what?
Of
waste, garbage.
Milords. Milords, I will just place some footage. I have a pen drive, Milords, with me just to prove prima facie, Milords. There are 3 points for your false for your Lordship consider. There are 3 facets, Milords, which falls for your Lordship consider. First, whether the dumping site is adjacent to the airport or not. Aerodromes area. Second, Milords, whether the allotted land or the dumping site is a approved site or not, Milords. Second. Third, Milords, what is that? Whether the dumping site has necessary permissions to run, like they have to take pollution control board permission, and if it's near to the airport, they have to take a permission from joint director or director of civil aviation and different authorities, including urban local bodies and others. Well, just to prove my case to the first point, to substantiate that there is existence of a illegal dumping site, Milords, to adjacent to the boundary of an airport, Milords, I'll place this pen drive, which may be played, Milords. There is a footage, Milords.
My lord, let them, sir. I'm appearing for BMC.
Last time also something was shown to us.
No, my lords, I'm appearing for BMC.
Right.
On last occasion, we had presented a video showing that plot is not a dumping ground anymore.
Right.
The plot in the prayer of the earlier petition, my lord. So if he grieves, let him file another case, my lord. How can he be an intervener in this? How can he be an intervener in this case?
Because
that has been satisfied by the BMC as per your last order, my lord, that the particular plot being mentioned in that petition is not being used as a dumping ground. So therefore, if he has any grievance, he can file another case and we'll look into it.
No, but that will only multiply
I may
litigation.
be permitted to appear on virtual modes, my lords.
All right.
I'm for the petitioners, my lords.
Yes.
On the last occasion, your lordship had directed to conduct a survey, my lords.
Yes.
Nearby the airport runway, whether any solid dumping is, waste of solid dumping is continuing or not, my lords.
Yes.
I pray for some more time, my lord, to file a survey.
All right. Where is?
Isn't that I've already given there?
No. Have you given her a copy?
A copy of Milords.
The whole thing is whatever is shown to us, a copy must be given. Even if it's a video clip, you only have to put it in a pen drive now. That's
Milords,
all.
I do not have an extra pen drive. I will.
No, she'll give you the pen drive.
Milords.
Milords, dumping is still continuing, my lords. It's just
All right. Milords, may kindly have a glance to the video. I will also supply the copy to my learned senior, Milords.
Which one, sir? There are so many videos.
There are 2 videos and 3 photographs, Milords. There are 2 videos and 3 photographs, Milords. 3 photographs of satellite images, Milords. Milords, this is the main road. If your lordship see, there are vehicles dumping vehicles. This is the dumping site. Your lordship may there are barbed wires. Your lordship may kindly have a glance. There are barbed wires.
One minute. When was this taken?
Just 3 or 4 days ago, Milords.
Okay, this is one video then.
There are another video, your lordship. There is another video, Milords.
it is located just at the backside of the airport.
Near the airport, you say. Where do we get that?
Milords, just I will. Your lordship will be clarify if seeing the image.
No, this camera is not straight.
Milords, may kindly see that there are barbed wires. That is the boundary adjacent to the airport, Milords. May kindly peruse the satellite images. That is the images that I have supplied, Milords. Milords, I would have shown your lordship. May kindly see this is the aerodrome. This is the external part of the airport, Milords. There are the internal part has the runway, Milords. This is the external part, and the shades, the blue shades are the dumping site, Milords, that are being operated, Milords. My internet connection is not good. Else I have shown the live satellite images, Milords. Internet connection. I have my laptop with myself, but I do not have a good internet connection, Milords. I would have shown the live satellite images, which could prove that there is which is adjacent to the airport boundary, Milords.
No, that we must get a sense. That's one of your main points, right?
Milords.
Next to the airport, there's a plot in which this dumping is happening.
Milords.
No, but your photographs don't show vis-a-vis the airport where you're.
Milords, just my internet is not fine. Also, I would have shown the live images, Milords, of the satellite images, which would have shown that the airport. If your lordship can see also, I do not ask your lordship to. No, ma'am, Milords. Internet is not connecting. Milords, prima facie, it shows that there is a dumping site which is.
You say, although some videos were shown in the court to substantiate the plea that the dumping of waste is happening in a plot next to the airport. Kama, the videos played before the court do not seem to indicate the exact location of the dumping yard. Paragraph, copy of the videos and photographs be supplied in a pen drive to learned counsel for the BMC within 2 days.
Milords.
Within 2 days.
And BDA also.
And BDA also within 2 days. The respective counsel for the Ms. Party appearing for BMC and Mr. Dayananda Mahapatra for BDA. Both state that they will seek instructions on these videos and if necessary file the respective affidavits before the next date.
Milords, my IA for intervention kindly be allowed. That is IA number 65.
Keep it on board. You say notice, let them accept notice.
Milords, notice may be issued.
Right. Notice in that intervention. List on. Immediate list. I think we can have it on 24th.
24th of
July.
this month?
4th of July. I'm grateful, Milords. I'm grateful.
Right.
Highly obliged. Highly grateful.
Item 42.
My lord, the order of the court has been complied with. Kindly,
We have appointed the members.
They have complied with.
We should all thankful to Mr. Das.
Yes.
For his effort, only all the posts are filled up.
My lord, I am also obliged to the court, honorable court,
right.
and thank the government. Para 4 of the compliance affidavit.
Yeah. A compliance affidavit has been filed. Where's the compliance affidavit?
All the 6 posts are filled up.
Stating that all 6 posts of the Orissa State Commission for Women stands filled. Paragraph. In that view, the matter of further directions are called for the present petitions disposed of.
Obliged.
Item number 43. 43, I am for the appellant, my lord.
By order dated 10/5/21, Lord.
Yes, Mr. Anand.
The order dated 10/5/21, your lordship has directed that for another writ be filed regarding his promotion to the post of the deputy director.
Yes,
I think.
I'll clarify that. I'll clarify that.
That decision of the writ application, any decision in this writ application may affect the outcome of the writ, my lord. That single judge has already issued notice and that is pending, my lord. So let these matters come after that is decided.
My lords, I'll clarify.
There are 3 matters. In fact, my non-senior friend is appearing.
I'm for the appellant.
No, that's it.
We are asking for time to the adjournment.
So your lordship, because that matter, lordship, you also granted liberty by order number 3 dated 10/5/2021, and this application has been filed and it application notice has been issued. Only your lordship keep it to vacation so that matter can be taken to dispose of that matter. Otherwise, any order will be passed.
Or that can be brought here.
Lordship, the short point involved here is, in fact, the
And there is no interim order in our favor.
My humble submission is that part of that order with regard to the promotion, that is subject matter of the writ application which has been filed subsequently. So the state, and since I am an agency, I am under the aegis of the state government, both the Planetarium and the state government, they have filed writ appeals
And this writ appeal subject matter is now has to be confined to the increment part only. Only that part you'll
increment part.
Yes.
No. There are two aspects of it, my lord.
The promotion aspect.
That is, one is promotion to the post of planetarium engineer from 1998. Another is that 4 increments, whether that will merge into the revised scale or it will be protected, that is for your lordship.
Anyway, there's no urgency in these kind of matters.
No?
There's no urgency in these matters anyway, sir. So it is stated that the writ petitions before the learned single judge are still pending.
Yes, WPC 1281 of 2022 is pending before the single judge.
1281 of 2022 is still pending before the learned single judge and is expected to be taken up for hearing in July.
If you also will request this honorable single judge.
Let's check.
If you also will request this English
It is very difficult to get a date to talk. No specific date is given by any bench.
That is my humble submission before lordship is that writ application is independent of this.
Right.
That is independent. That has nothing, because that promotion.
It has a bearing if
that will not have a bearing in view of your lordship's order dated 10/5.
If I am promoted from 1998,
one cause of action may not survive.
Yes.
Next date is it is stated that writ petition civil
10/5.
He's already been promoted.
Well, I was looking at that video, lighter man, and I was going through the lordship's proceedings about digital or things. I was just telling you that I am too old to cope with this.
No. Actually, it's only about age has nothing to do with it, sir.
Your lordship has an advantage of 17 years. Than me.
No, I know. But some very elderly lawyers in Punjab, they got very, into it.
Why not your lordship at least direct at least for training, some training?
Even for a virtual mode, my lord, but I am coming, really I am not keeping well nowadays, but I am compelled to come, my lord. Virtual, I am not very comfortable. And every time I have to depend on him to switch over from this court to that court.
But it's so convenient actually from one point of view.
One point of view, it is very convenient now.
Okay, it is stated that writ petition civil
1281 of 2022.
1281 of 2022 involving the issue of promotion is still pending before the learned single judge. First of all, although no date has been fixed in the said writ petition, it is stated that the outcome of that petition might have a bearing on the present appeals, on the issues in the present appeals. Full stop. In that view of the matter, this writ appeal, or these writ appeals, these writ appeals are direct listed for hearing on 5th September.
I think the writ appeal number 115 of 2020 that is filed by a private party. I don't think they have any interest further because already that has been implemented.
All right. 115 of 2020, it is stated that the appellant is not interested in pursuing the matter further.
But I am not the appellant.
Yeah, none appears for the appellant. You say none appears for the appellant. No, he's not there. None appears for the appellant. Dismiss for non-prosecution. All right.
Item number 44, 44, 45, 46, 47, 48, 49, 50. All are separate special.
Sartabada. Okay. This is all linked with that.
Already in that in that list, one case has been wrongly listed, writ appeal 1421 of 2022. That is a Board of Revenue matter. And that has to be deleted.
Okay, 1421 of 2022.
1421 of 2022.
Right.
Writ appeal.
Yeah. list on 13 September.
My lord, begging your lordship's pardon, my lord. Item 9. I was
Tell us.
none
what
of
it
yes,
is.
ma'am.
Yeah, tell us what it is.
My matter relating to public interest litigation, my lord. The funds at page 11, annexure 1, serial number 2. May I read, my lord?
Yes.
Page 11, serial number 2. Construction of new building for daycare, PHC new, Nadiga under NHM 2022-23, my lord. It is a PHC situated at Nadiga, Gram Panchayat. The place is Nadiga. But at annexure 12, my lord, I have filed a legible copy at 12A, my lord. The CDM and PHO.
1 minute, annexure 12?
And page 12.
Page 12.
Page 12A. Legible copy. Page 12 is the government copy, and I have typed out a legible copy, my lord. The CDM and PHO has proposed the building should be constructed at Phalpur, Khata number 908, plot number 1441, 1442, my lord.
All right. The petitioner's representations, bracket annexure 3, will be examined by the Tahsildar.
My lord, may I draw your lordship, may I pray, my lord, the submissions made before your lordship by way of PIL, my lord,
Collector may
that may be taken into consideration by collector.
Correct. All right. By the
The
collector.
submission made in the PIL.
And after notice to the petitioners. And the video will automatically participate, or
No, video is the executing agency.
BDO is the executing agency. Collector is the
a reasoned order shall be passed not later than 1st August 2023 and be communicated to the petitioner within a week thereafter.
Till then status quo, otherwise they will construct at another village. Your lordship is hearing a case with regards to Chandni Chowk and Mohammedia Bazaar, just like that case, my lord.
All right.
No, it is not like that. That is
Another village, my lord. The funds, my lord, my learned senior Kutia sir is also belong to Damnagar, my lord. He may also assist your lordship, my lord.
Then better give him the representation.
He is the best man to consider, my lord. He knows everything, the village area.
All right.
Oblige, my lord. Till then, my lord,
No, that the collector will take care of.
You will move the collector for interim order.
Yes.
I will move the collector for interim order, my lord.
Some more matters. Separated. All right. This 677, I think, is really big. That takes
I will move the IA before the collector.
Yes. I've said that already.
That is there.
May I call the password?
Yes. Item 1. No?
Quick list password matter item number 1.
Yes, my lord. Petitioner representation before the Tahsildar Baleswar Sadar, Tahsil
As representation bracket annexure 2 shall be examined by the collector Baleshwar and of notice to the petitioners and opposite parties 5 to 13 and giving them a hearing. A reasoned order shall be passed not later than 1st August and be communicated to the parties within a week thereafter.
Password matter item 23.
23.
Here, my lord, for the same issue, 3 original applications were moved before the tribunal, my lord. And the 3 original applications were dismissed for default.
Okay.
And after abolition of the tribunal matter, all the matters came to this honorable court. And these 2, my lord, other 2 writ applications, my lord, that has been restored and has been fixed to 10th May, my lord.
Show me.
Well, that order is not, my lord, the number I can give, my lord.
All right.
My lord, WPC OAC number 3585 of 2015 and WPC OAC 3587 of 2015, my lord.
All right. You see, the impugn order, it is stated that While the impugned order has been passed in WPC bracket OAC number 3586 of 2015, there were two other writ petitions with identical reliefs, that is WPC bracket OAC number 3587.
85 or 15?
85 and
87
of 2015. The orders in both of which have been already set aside by this court. In writ appeal numbers?
No, my lord. That restoration application came to this honorable court, my lord.
That's right.
In two writ applications.
Which have already been restored to file.
Restored to file.
Restored to file by the learned single judge and listed for hearing on?
10th May, my lord.
10th May 2023. Paragraph. In that view of the matter, the impugned orders are hereby set aside. And WPC OAC number 3586 of 2015 is also restored to the file of the learned single judge to be listed along with the above writ petitions on 8/5.
On 10/5, my lord.
Day after.
Day after.
All right, on 10/5/2023. Pass the order today, sir. The writ appeal is disposed of in the above terms.
Item number 27.
My pleasure. Here, my lord, the writ application challenging the order of honorable single bench, my lords. There is judgment dated 26/8/2021. Here, my lord, before my lord, I draw lordship's attention, my lord, that previous WPC OAC 4378 of 2012 may be taken fast so that I will convince your lordships it will be better for me to satisfy lordships.
What is it? Which matter?
My lords. WPC OAC 4378, the order of the honorable single judge matter, my lords.
Yes, yes.
Best, my lord. Here, my lord, the petitioner, annexure 1, my lord, petitioner, my lord, was appointed, selected and appointed as Shipoi in the Department of Police, Central Police, Odisha State Armored Police, my lord, OSAP, Malkanagiri. He was selected, my lord. After selection, my lord, he was sent for training. My lord, annexure 2, that during continuous training, he was removed from the service on the ground that during verification of a character and antecedent, it is reported that he is involved in a criminal case. That is the sole point, my lord, that during continuous of a training, findings that...
No, you didn't disclose it, sir.
That
non-disclosure.
Non-disclosure. My lordship correct, my lord. My lord, what happened in thereafter, my lord, annexure 4 is I have filed, my lord, that the pendency case issue was not my lord known to the petitioner. That is the judgment was passed annexure 4, my lord, page 15, my lord, that criminal case ended in acquittal, my lords. That is the offences of very smallest petty offences, my lord. Offences are 451, 323, 294, 506 IPC, my lord.
The point is non-disclosure, not about the gravity of the sentence or whatever.
My lord, what happened in the meantime, my lord? Again, my lord, that after order of acquittal passed, the petitioner approached...
We are now only on non-disclosure, sir, not what happened in the criminal case.
Not after
the acquittal happened afterwards. It did not happen earlier.
Not this criminal case, my lord, was happened during the family members only, my lords.
Whatever, sir.
It was not known to the petitioner at the time of filing, my lord, the affidavit at the service.
He has obviously been arrested in the case.
No, my lords. That is the case, my lord. Therefore, I try lordship to convince your lordships, my lord. It is a petty offense of 506 which I again acquitted, my lord.
You don't mix up, sir. Question is, were you aware and did you disclose?
My lord, I am
not how. What is the gravity of the offense and have you got acquitted? That is not the question. We are not on whether it's petty offense, serious offense, acquittal, conviction. We are not on all that. We are only on, are you aware of the criminal case? Did you disclose it?
No, that is not aware of the petitioner.
No. How do we know that?
Therefore, my lord, after getting lordship, satisfying lordship, that is the first ground, my lord. So the second ground, my petitioner, my lord, that the orders under which rules, my lord, only PM rules, my lord, which, my lord, he has removed, my lord, that act is not applicable to the petitioner, my lords. Under which, my lord, the removal order passed, my lord. That is your lordship PM rule, my lord. They have stated annexure 2, my lords.
Sir, you are missing the point. That's the whole problem. This is not about mere technicality. This is about non-disclosure, sir. There's a criminal case pending against you.
That it was not known to the petitioner. How
does one establish that is the question, sir? Was an FIR registered? Was a charge sheet filed?
FIR, my lord, I have also annexed to lordship. Kindly have a glance, my lord. I have also annexed my lord a petition. Lordship says.
Sir, we are on something else. You are on something else.
No, my lord. I understand what the lordship are saying, my lord. But this was not my lord. Petitioner not our my lord. The criminal case has been filed.
No.
And that the family, my lord.
Let's see the single judge. What the single
now, your lordship, my lord. I have also, my lord, brought some 3-4 judgment.
First facts. Let us see what the single judge says.
Annexed to Page 27, my lord.
Para 6.
Yes. Para 6 of judgment of honorable single bench, my lord. Yes, my lord. I'm permitted. Now coming to the merits of the case. It is clear upon perusal of materials on record that while applying and filing in the verification form, the petitioner had suppressed that he was an accused in a pending criminal case. Further, your rejoinder has been filed disputing the argument relating to suppression made in the counter. The appointment order clearly indicates that the appointment of the petitioner was provisional and subject to satisfactory verification of character and antecedent. It was also indicated that in case any falsity and adverse report, he would be discharged from the service summarily and whenever necessary criminal proceedings will be initiated against him. Further, a perusal of verification rule under Annexure A clearly show that a reply to question number 7 and 8 of the verification rule, wherein he was required to state whether he had ever been an accused in any criminal case and whether any criminal case was pending him. He had replied in the negative, though at that point of time, GR case number 409 of 2014 stroke, TR case number 146 of 2011 was pending against him. Also at serial number 19 in the application form at Annexure B, he has given a false answer that he is not involved in any criminal case. Therefore, suppression of material information in this case is writ large. The appointment order Annexure 1, Rule 11 of Odisha Special Armored Police Rules 1953 and Subclause 1 of Clause 13 of 2006 order clearly speaks of requirements of verification of character and antecedents and appointment being made subject to clearance from character and antecedent analysis. At such background, impugned order has been passed involving Clause 6 of Rule 67, read with Rule 668 of Rules Odisha Police Rules. Let us now discuss as whether the removal order can be passed relying on the above noted rules so far as a sepoy is concerned. For this, we may note that as per Section 4 of the Odisha Special Armored
So there is no mention of the fact that you are argued before the single judge that you are not aware of these proceedings. Where have you argued with the single judge?
My lord, I have the argued, my lord, before the honorable single. I have the same counsel, my lord.
Where is it?
The division bench also, my lord.
Which line in this judgment talks of that?
But I have argued, my lord, that the petitioner is not aware that he has any criminal cases, my lord. And before division bench, I am also arguing, my lord, for that he has not aware that a criminal case pending, which, my lord, between the family, which are petty offences, my lord. After acquittal, petitioner came to know that a criminal case was filed, for which, my lord, she filed the representation that the removal order may be recalled and he may be reinstated, my lord, in the service. After order,
What happened in that criminal case? Therefore, acquittal.
Acquittal order passed, my lord, not conviction, my lord, acquittal order. In this regard, my lord, there are so many Honorable Supreme Court judgment. Once acquittal order of petty offences are, my lord.
Please listen, please. How the accused was acquitted in his absence? Without facing trial? If you are not aware, then how the accused has faced trial?
Now, after that, I came to know that during, my lord, the course of training, that this order of removal passed. Thereafter, petitioner came to know, and he, my lord, go to the criminal court and verified that is gone. Therefore, contested the case and got acquitted, my lord. But here, my lord, also we can't have a glance annexure, my lord, FIR, which has been mentioned in Odia, but a single word against the petitioner, a single word. If lordships know,
sir, we are not concerned about the FIR. We are concerned about the non-disclosure.
At the non-disclosure, lordship kindly have a glance.
It has been clearly observed in the impugn order that you have suppressed.
That's my impugn order challenge before lordship. You lordship kindly have a glance to annexure, my lord, 8 of FIR, my lord. Was a single word against the people of the single word. I will withdraw my lord data application, my lord.
Oh, so we should treat it as a 482 now. You tell us.
My lord,
despite your acquittal, you want to treat this as a 482.
I draw your lordship's attention, my lord, that my lord, justice is well known so far Odia annexure is concerned. But there is single word against the petitioner that is involved in the criminal case, my lord.
Is that relevant here, sir?
Not to satisfy your lordship, my lord. To convince my duty to convince your lordship.
No, is it relevant?
If my lord lordship satisfied that not a single word against the petitioner, that it may your lordship may consider that order was passed by the single judge, your lordship may interfere, my lord. If there is no single word against the
what will we do after we consider that? What
suppose with your permission, my lord, I'm saying. Suppose that there is one affair has been lost, my lord. There is allegation against the petitioner that is involved in the case, or he has some allegation against the affair, my lord. There are two lordships that you find that the good as interfere, need not record, my lord. So here in the case, my lord.
No, 1 minute.
Your client have a glance, my lord. The client have a glance to Odia annexure of the affair, my lord. But the poor, my lord, petitioner with the Sipoi, my lord. During my lord sessions of training, he has been removed, my lord. A lordship kindly have a glance to Odia affair, my lord. But a single word against the petition that is an
this is the 6th time you're telling us that in the FIR, there is not a single word against you. You have repeated it 6 times? Or you want to tell me one more time, you tell me.
No.
If you're not satisfied that you've not said it enough, please say it again. So what you're saying is, in the FIR, there is not a single word against your client, correct? No. I'm asking you, how is that relevant as far as you're suppressing the pendency of a criminal case against you in the application form? How is this relevant? If you are listening to a 482 petition and you're asking for quashing of an FIR, you can argue saying, sir, there's not even a mention of my name in the FIR. How is the criminal case sustainable against me? You don't want to argue it because you have in fact got acquitted in the criminal case. Correct?
Okay.
Poor, rich and all has no meaning here. Your client has already got acquitted in the criminal case. Why has your client got removed from service, sir? Because his name was in the not mentioned in the FIR. Because of that, he got removed from service. Why did he get removed from service? Why did your client get removed from service?
Because of pendency of a criminal case, he was suppressed during.
So argue that case. Don't go on saying 6 times, 7 times, sir, his name is not there in the FIR. Not relevant.
To satisfy lordship's ballot, I've said for that.
No. How will you satisfy? You have to answer the point.
Will lordship's permission, my lord. So, but another ground.
So, if you're a poor sepoy, you can suppress facts. Is that your argument?
The second ground of attack, my lords.
First, you answer this question.
My lord.
If you're a poor sepoy, you can suppress facts?
No.
So why are you arguing that again?
The suppression of fact, not intentionally, my lord, so for my argument.
Is that relevant again? Intentional, non-intentional, is it relevant?
With your permission, my lord, second ground of attack, my lord, I am saying, my lord, the order has been passed. My lord, the order rules, my lord. Lordship kindly have a glance, my lord, the judge, honorable judge, single bench judgment, my lord. page 4 of judgment, my lord, running page, my lord. He also submitted that since the petitioner was a sepoy, Odisha police may permitted to read, my lord. After just 3 lines, my lord, top. He also submitted that since the petitioner is sepoy, the Odisha police rules under which the removal order has been passed have no application to him, as service condition of a sepoy are governed by Odisha Special Armed Force 1946, Odisha Special Armed Rules 1953, and the Odisha Special Armed Police Battalion of British applicant as the order of removal not passed under this act, my lord. Only orders has been passed under PM rules, my lord, which is not applicable to the case of the petitioner, my lord. That is judgment, page number 4, from top 3 lines.
The answer is in page 8, sir. Internal page 8.
Mallards. Subpara, my lord, permitted to read.
Page 8, sir. Internal page 8.
Again.
The appointment
in such
order.
Background.
No, above that, sir. The appointment order.
The appointment order annexure 1, rule 11 of Odisha Special Armed Police Rules 1953 and sub clause 1 of clause 13 of 2006 order clearly speaks the requirement of verification character and antecedents and appointment being made subject to clearance from character and antecedent angle, millers.
Continue reading, sir. Now.
In such background, the impugned order has been passed involving clause 6 of rule 673, reduced rules 668 of Odisha police rules. Let us now discuss as to whether a removal order can be passed relying on the above noted rules so far as the sepoy is concerned. For this, we may note that as per section 4 of the Odisha Special Armed Police Act 1946, sepoy falls under category of Special Armed Police Rules. Subclause 4 of the clause 13 of 2006 order makes it clear that terms and conditions of service of a sepoy shall be same as assigned to them in the Police Act 1961, Odisha Special Armed Act 1946, and rules and orders framed under this act and in the instruction of the government issued from time to time preference to Odisha Police Manual Rules 1940 makes it clear that it contains both rules made by state government as well as rules and Odisha framed by Inspector General Police with the approval of state government under the provisions of the Police Act 1961. And those are binding on all police officers. Since sepoy is a police officer, sepoy is not police officer, employee, an officer, as indicated earlier, there is no doubt the rules under Odisha police rules will apply to the sepoys. Therefore, this court has no hesitation in coming to conclusion that no illegality has been committed by the authority in invoking the provisions of Odisha Police Rule 1940 to pass the impugned order. Now coming to the
1 minute. So what do you say to this?
Sepoy millers, they have stated that sepoy is not officers of the police department.
Anyway, the full answer to your second point.
This rules not applicable to the petitioner. So because he is not coming under the Odisha police manual rules, my lord.
Yes, so he is a sepoy, is a special armed police.
My lords. The order has not been passed under special act, my lord.
All right.
So therefore, my lord, if the lord's permission, my lord, that my lord, Honorable Supreme Court, my lord, 2-3 judgment I want to place. Because I have short time, your lordship is begging first hour that time may be given, so preparation, your lordship, my lords. There's some judgment in my favor that Honorable Supreme Court says that if, my lord, the offence is petty and that is acquittal in favor of, and no reason has been given regarding, so his case may be considered and Supreme Court allowed the case of the lordship, my lord. Year 2016 Supreme Court 3598, my lords. This order passed Honorable Chief Justice Ranjan Gogoi, Arun Mishra, and Justice Prafulla Pant, my lord. 3 Judgment plus 5 judgment, my lord. Here, my lord, I may permitted Avtar Singh case, my lord. That is a unique case, my lord. Avtar Singh versus Union of India. Here, my Kasitam, I am reading, my lord. Constitution of India, Article 16, Article 311, dismissal without inquiry, my lord. Ground suppression of information of submitting false information in verification form about criminal prosecution, arrest, pendency of criminal cases, discretion of employer to condone, lapse of or to terminate when can be exercised stated, my lord. In this case, suppression was made, my lord, but Honorable Supreme Court says that when and where, my lord, it will be considered. Of that sentence, your lordship is known, my lord, there is a unique judgment, and that is.
We don't know anything, sir. We don't know anything. Totally illiterate. For me, unless I read Avtar Singh judgment, I don't know it. I must have a copy of the judgment with me. You are very brilliant, sir. By looking at the head note, you immediately know the judgment. We are not as brilliant.
No,
for us, we have been told that unless we read the judgment, we should not draw inferences about judgment.
No, lordship permission, I'll pass my lord.
Full permission, sir. We are granting you full permission.
No, sometimes so that it will get just faster, my lord, the condonation of matter, my lord, delay condon. I think, my lord, presumption that your lordship will delay condon, matter will come to another date for hearing of the case.
Correct.
I presume, I wrong, my lord, for that. I may be wrong, lord. But I presume, my lord, that. Therefore,
we have unnecessarily delayed you today in court. No? You wanted to just do the delay and move to other courts. We have unnecessarily detained you. We've heard you now for 20 minutes.
No, that's
we should not. We should not have done so much, sir.
Very beginning, by telling with your permission, I'm doing similar.
Always, sir, and we are always giving you permission. Even now, we are permitting you. You are going on asking permission. We are going on giving you permission.
So, lordship's permission,
yes, again we are permitting you. We are again permitting you, sir.
Well, I'll supply the judgment of Honorable.
Please do that, sir. Please.
Supply.
Collect it.
I have no Xerox copy, my lord, photocopy, so that
we'll condone everything, sir.
Lord, I have no photocopy.
Delay also we condone. This also we condone. No problem.
Lord, I have no photocopy, my lord. Therefore, just
no problem. What else, sir? Tell us. Anything else? What other arguments, sir?
On the twofold grounds, my lords, my argument was and here also is that the order of dismissal on the ground that regarding suppression of criminal pendency of a criminal case is not intentional, my lord.
All right.
And the order of removal passed not in the rules as per, my lord, the police, under which, my lord, he has served.
Or the present appeal is directed against a judgment dated 26th August 2021 passed by the single judge, dismissing WP Civil (OAC number 4378 of 2012 filed by the appellant, questioning the order dated 9/10/2007 passed by the Commandant 4th Orissa State Armed Police (OSAP) SS Battalion Malkangiri, by which the petitioner, who was engaged as a sepoy in the OSAP, was removed from service. Full stop. The appellant had also challenged the appellant also sought a mandamus to the Director General of Police to reinstate the appellant in service in view of a judgment dated 5th September 2012 passed by the JMFC Navarampur in JR case number 409 of 2004 / TR number 146 of 2011. Paragraph. After undergoing this process of selection, the appellant was appointed as a sepoy on 25th December 2006. Full stop. While he was still undergoing training, he was removed from service by the aforementioned order. Since, during the verification of his character and antecedents, it was found that he was involved in the aforementioned criminal case, which was at that relevant point in time sub judice. Paragraph. On 18th October 2007, the appellant filed a representation praying for reinstatement, as he was not actually involved in the case, although his name was stated in the FIR. Full stop. According to the appellant, even after his acquittal on 5th September 2012, nothing was done to recall his order of removal from service. And therefore, he filed initially OAC number 4378 of 2012 in the Orissa Administrative Tribunal, bracket OAT, full stop. After the abolition of the OAT, the matter was transferred to this court and registered as a writ petition with the aforementioned number. Paragraph. In a reply filed to the said petition, the respondent authorities herein took the stand that the information regarding his involvement in the criminal case was suppressed by the appellant, and therefore invoking Rule 673 bracket small c, read with 668 of the Orissa Police Rules, he was removed from service. Full stop. It was also denied that any representation had been received from the appellant. Paragraph. Mr. Das, learned counsel appearing for the appellant, who also conducted the case before the single judge, reiterated his submissions before the learned single judge, namely that the appellant was not actually involved in the criminal case, and this had been notified. This had been taken note of by the JMFC while acquitting him. Full stop. He claimed that the appellant was not aware of the pendency of the criminal case, and therefore omitted to mention it in the application form. Full stop. Such omission, according to him, was therefore not deliberate. Full stop. Paragraph. It was also argued before us, as was argued before the learned single judge, that since the appellant was a sepoy, the Orissa Police Rules has no application. And according to him, they are only governed by the Orissa Special Armed Police Act 1946 and the rules thereunder, as well as the Orissa Special Armed Police Battalion and Orissa State Armed Police, bracket Special Security, bracket Battalion Services, bracket Method of Recruitment and Conditions of Service of Sepoys, bracket Order 2006, bracket the 2006 order. Paragraph. The learned single judge noted that in the verification roll dated 25th December 2006, in serial number 7, the appellant had stated that he had neither been accused in a criminal case nor had he ever been in prison. So this was at a time when GR case number 409 of 2004 was still pending against the appellant. Again, at serial number 19, in the application form dated 6/11/2006, the appellant gave a false reply to the question whether he was involved in any criminal case. Full stop. Paragraph. The learned single judge also noted that rules 11 and 13 of the Orissa Special Armed Police Rules 1953, as well as clause 13 bracket 1 of the 2006 order, emphasized on verification of antecedents of candidates. We'll stop further. The 2006 order itself was made in terms of the Police Act 1861, paragraph. Having heard the submissions of Mr. Das and perused the order of the learned single judge, the court is not satisfied that any ground has been made out for interference. So as far as the suppression of the material fact is concerned, although Mr. Das claimed that the appellant was not aware of the pendency of the criminal case, the facts seem to reveal otherwise. Full stop. No such plea appears to have been taken before the learned single judge. Full stop. When it was put to Mr. Das that the appellant could not have possibly been acquitted without actually appearing in the criminal court, he volunteered that it was only after he was removed from service that he appeared in the criminal court, and was thereafter acquitted. Paragraph. The court is unable to accept the above plea. Full stop. Materials had to be placed on record by the appellant to show that he was not aware of the pendency of the criminal case prior to his removal from service. Full stop. These were the offences for which he was tried were under sections. What sections, sir? Criminal
matters. Under sections, that is judgment that is placed 441, 451, 323, 294, 506, and 34 IPC. Judgment page number 16 it will mention.
Some of these offences are obviously cognizable, and it is unlikely that the appellant would not have been arrested and would not have been enlarged on bail for those offences. There is no way that the appellant could not have been aware of the criminal case. Full stop. If it was the appellant's contention about his not being aware, the burden was on him, in the above circumstances, to prove it. Full stop. The appellant did not make any effort to do so. Paragraph. Under Rule 673, read with Rule 668 of the Orissa Police Rules, the suppression of such a material fact has serious consequences. Full stop. The verification rule prepared in terms of Rule 673 makes it clear that any statement regarding character of a person is found to be false, then he shall be removed from service. Paragraph. Consequently, the court is satisfied that in the present case, the ground on which the petitioner was removed from service was clearly made out from the facts of the case. Paragraph. Consequently, the court is not persuaded that the decision of the Supreme Court in Avatar Singh versus Union of India, AIR 2016 SC 3598, would support the plea of the appellant that there should have been a full-fledged inquiry prior to his removal from service. Full stop. With the fact of suppression of a material fact, of a material particular in the application form regarding pendency of the criminal case, being unable to be disputed, even the holding of an inquiry would have been a futile exercise. Full stop. Paragraph. For the same reasons, the court finds that the mere nature of the offense, being serious or not, would not determine the outcome of suppression of a material fact in an application form for a post in a disciplined force like the police. Full stop. Consequently, the decision of the Supreme Court dated 19/8/2011 in CA number 7106 of 2011, bracket Ramkumar as the state of UP, also is distinguishable on facts. Full stop. Paragraph. The court finds that the other decisions relied on, that is, decision dated 17 March 2011 in CA number 1430 of 2007, bracket Commissioner of Police versus Sandeep Kumar, and the decision of the Calcutta High Court in WP Civil, in WP number 26379 of 2016, bracket Bibrata Bishwas versus Union of India, AIR Online 2019 Calcutta 796, is also not helpful to the appellate. Paragraph. For the aforementioned reasons, the court is unable to find any ground to interfere with the impugn order of a single judge. The writ appeal is accordingly dismissed.
All right. My lord, one matter in that special list.
This is Raman's case, is there? Okay.
Quick list resolution item number 1, CRLMC 1767 of 2019.
Beg pardon, Lord. I beg to mention, my lord, a trial has been stayed for several years, my lord, due to the interim order passed by this honorable court. A 302 case, my lord, CRLMC 3270 for 2018.
For listing?
Listing for listing.
So tomorrow.
Pardon to mention, my lord. My lord, item number 31 may be permitted to withdraw, my lord.
Which is your item, sir?
My lord, item 721.
All right. Yours is 31.
Yes, my lord.
3171 dismisses withdraw.
Bless your lordship. My lord.
Item 1, CRLMC 1767 of 2019.
None of this dismissed.
Item number 2.
None of this dismissed.
Item number 3.
Save order.
Item number 4.
Save order.
Item number 5.
Item number 5, Lords, I have no instruction. I filed the memo.
Memo taken on record. There's no instructions disposed.
Item number 6.
May I please, your lordship, item 6. Lord, here petitioner 1 and 2 are the in-laws, father-in-law and mother-in-law. Petitioner number 3 is the husband, my lord. Here I am challenging the cognizance order against the petitioners, my lord, under section 498A, 323, 506, 406, 34 of IPC and 4 of DP Act, my lord. In meanwhile, my lord, the opposite party number 2, wife of the petitioner number 3, my lord, already married somewhere, my lord. And degree of divorce already passed ex parte order against the opposite party number 2, my lord.
Take all this, please.
On that light, my lord, I am filing one additional affidavit, my lord. Already filed one additional affidavit.
What is that? Affidavit of whom? Affidavit of the wife.
Affidavit by the petitioners, my lord.
What is that? That won't help you, sir. Permitting the petitioners to raise all pleas at the appropriate stage.
Pray one small thing, my lord. Kindly expedite the trial, my lord.
No, that you can.
It will be not fruitful if the pending case.
Because of this, it was not going on, sir. Now it will go on. Yes.
Item number 7.
May I please, Your Lordship? The petitioner challenges the order dated 19/10/2020, Annexure 2, wherein the Honorable Session Judge has rejected the prayer for release of seized cash in favor of the petition. Lordship, kindly turn to Annexure 2, page 13 of the order, para 6. After hearing from both the sides in virtual mode, I have gone through the seizure list, wherefrom it is noticed that on 6/4/2020, huge quantity of country liquor, Aska 40, were under the illegal possession of the accused petitioner, and he was also in possession of sale proceeds, which are seized on the preparation of seizure list. On the perusal of the statements of the witnesses, it is prima facie available that the accused petitioner was apprehended while he was selling the country liquor to the customers, and the sale proceeds were seized from his possession. In the above situation,
what happened in the criminal case?
My lord,
what happened in the criminal case?
status of the case.
My lord, status, my lord, the no confiscation proceeding has been initiated. My lord.
Sorry?
No confiscation proceeding has been initiated.
No, the case is still pending.
Yes, my lord.
Oh, it is conceded by counsel for the state that the criminal case is still pending and a charge sheet has been filed, and yet no confiscation proceedings have been initiated till date. Paragraph, in the absence of confiscation proceedings under section 102. Where is that? Which?
457.
457.
Released.
Yes. 468.
No, confiscation is under which provision?
Under section 71 of Excise Act, Your Lordship. And since the cash is involved, my lord, the cash are not subject to confiscation.
Counsel, the petitioner points out that Section 71 of the Orissa Excise Act 2008 mentions and talks about single quote seizure of property liable to confiscation, unquote, and this does not include cash. To stop in the present case, the explanation for seizing the cash from the petitioner is that it was the sale proceeds of
country liquor.
Of country liquor, bracket Aska -40, in his which he was illegally possessing. Full stop. Since the prosecution has sought to bring the criminal case under the OE Act, but clearly the confiscation had to be explained in relation to the said statute, and in particular section 71 thereof, paragraph. Admittedly, no proceedings for formally confiscating the cash has been initiated till date. Stop. That view of the matter, the sum of rupees 100,140 in cash stated to have been seized by the Kandagiri police in the aforementioned CT number 167/71 of 2020 is now directed to be returned to the petitioner within 4 weeks. This will be without prejudice to the case of the prosecution against the petitioner in the criminal case, or the defense thereto by the petitioner. The petition is disposed of the above laws.
Item number 8. Item 8.
None appears.
Item number 9.
Item 9, your lordship's liberty may kindly be granted.
All right.
Item number 10.
Item 10, my lord, liberty may be given to raise all these points at the before the appropriate forum.
You're not clear. What are you saying?
My lord, liberty may be given to raise all.
Permitting the petitioner to raise. All right.
Item 11.
Lord, here, NBW was issued on 21/6/2021, your lordship.
What's the offense, sir?
Offenses are all the magistrate terrible, lordship. Maximum punishment is for offense 8 of the PESCO Act, maximum 5 years, your lordship. In view of the judgment of the Honorable Supreme Court,
since how long?
Kumar versus State of Bihar, your lordship, kindly direct to consider my surrender.
2021 NBW, sir. You're coming to 2023. NBW was issued in June 2021.
My lord.
You're coming 1.5 years later, sir.
My lord, he is a labor class people, your lordship. I went to Kerala for doing labor work, your lordship.
Still, sir.
Kindly consider, your lordship, in view of the judgment of the Honorable Supreme Court,
honest will appear.
Honest Kumar versus State of Bihar.
Before the, which is this court?
Pardon, your lordship.
Anticipatory bail was rejected.
She is not approached, your lordship.
Sorry? Anticipatory bail was rejected, I think, on 29th.
Yes, your lordship. I have given certificate, your lordship. Anticipatory bail was rejected.
That's how you filed 482.
Yes, your lordship.
Another alternative anticipatory bail.
That is, your lordship very well know this.
Yeah.
Lordship, maximum punishment is 5 years. Therefore, I am praying your lordship kindly consider my.
The present petition has been filed as an alternative to the rejection of the anticipatory bail application filed by the petitioner on 29 June 2021. Consequently, the court is not inclined to entertain the present petition. Dismissed.
Item number 12.
May I please, Lord? My lord, challenging the Annexure 3, which is the chemical examination report, my lord. Petitioner is praying for the default bail, my lord. Here in this case, my lord, the chemical examination report
of the NDPS Act. 20B of the NDPS Act.
The chemical examination report not filed in time. I am not in the ground of the, that is not in file time, my lord. The chemical examination report filed on 3/4/2023 stating that the report has came on 30/11/2021, my lord, which is kept by the IO, my lord, without intimating the court. That's why I filed this petition for the default bail, my lord. Here, my lord, FIR is lodged on 5/6/2021, my lord. And cognizance of the case has been taken, that is 18/11/2021, my lord. Till that date, my lord, on dated 18/11/2021, till 1/3/2023, the orders reflect that there is no chemical examination report that. On dated 3/4/2023, my lord, during the consideration of the charge, my lord, the PP has supplied the chemical examination report on the dated that 30/1/2021, my lord. 1.5 years they have kept without notice to the court, my lord. And the court also entertained it without seeing that, my lord. There is no seal is there, my lord. Only it is received seal is there, my lord. It was not seen by the court also, my lord.
All right. Notice returnable before the roster bench on 4th July. He accepts notice. You say the relevant record be kept ready for perusal.
My lord, I have not filed the IA for stay, my lord.
There's no stay now.
Obliged.
All right.
Item number 13.
My lord, the petitioners challenging the order dated 17/8/2021, your lordship. On that day, the Honorable the London Lower Court
after getting information about the status of CRLMC number 2832 of 2006, wherein this Honorable Court has granted stay, got the order that the stay has been vacated. Thereafter, Your Lordship, warrant had been issued without giving any opportunity. Earlier, they were on bail, Your Lordship. I have annexed the copy. The petitioner number 1 was released on bail on 5/12/2006, and the petitioner number 2 was released on bail 23/8/2005. And Your Lordship, kindly see the impugn order. All those learned trial court received the vacation of stay order from the Honorable High Court, but without giving any opportunity, Your Lordship, straightforward issue NBW against the petitioner, Your Lordship.
Again, this is an order of June 2020, August 2021, sir.
Yes, Lordship.
What were you doing in all these years? Till 19th April 2023, what are you doing? You're at large.
My Lord, both.
What is the offense?
Offenses, sir, Your Lordship.
3 SC/ST is also there.
294, 341, 354, 506. 3 SC/ST, that is the occurrence of the year 2005. Later on, the SC/ST has been amendment, Your Lordship. An allegation is that Your Lordship, they were on bail, Your Lordship. I have annexed the certified copy of the release order of both the petitioners, Your Lordship. And Your Lordship, without giving any opportunity, Your Lordship, after getting information from this Honorable Court, the London Trial Court has issued a warrant, Your Lordship. And after apprehending arrest, they came before Your Lordship. Although warrant has been issued in the year 2021, but last month they were apprehending arrest, Your Lordship. Police, on searching police, they came before Your Lordship. And also kind of see the impugn order, Your Lordship. That is page 23, Your Lordship, on 17/8/2021. The London Trial Court should give in one opportunity, my Lord, for appearance, because the trial has been stayed by this Honorable Court, Your Lordship.
Only thing is, what were you doing such a long period? They're not even moved to arrest you then, clearly.
No, till date they
you
have
got the protection of the police anyway.
My Lord, they have not arrested, Your Lordship.
This is what happens, sir. Nobody's bothered. You know how many NBWs remain to be executed in the state? Running into 50,000.
My Lord, in this way, I am approaching to Your Lordship. If Lordship will direct to surrender on go and bail, the case will be streamlined, Your Lordship.
Petitioners are already on bail, and the impugned order issuing an NBW stay to be passed without giving him an opportunity to appear once. Particularly since the stay order was getting vacated. Paragraph in the circumstance directed that both the petitioners will surrender before the concerned court on 1st June 2023 at 11 a.m. Till then, the interim order, till then, the NBW in question will not be executed. But it is made clear that if the petitioners do not comply with the above direction, the aforementioned interim order will stand automatically vacated. It will be open to the petitioners thereafter to apply for appropriate orders before the trial court. The petition is disposed.
Item 14.
My Lord, permitted to withdraw, my Lord.
All right, dismisses withdraw.
Item number 15.
None of these is dismissed.
Item number 16.
Same order.
Item 17.
Same order.
Item number 18.
Item 18 will not the order of cognizance that is under challenge on the ground of not taking any sanction, Your Lordship. The petition
can be taken at the appropriate stage.
Petition the SB account in the head post office, Koraput, my Lord.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed.
Item number 19.
None appears dismissed.
Item number 20.
Same order.
Item 21.
Same order.
22.
Same order.
Item number 23.
No. 22 man after that. Item 22. I will misplaced man somewhere.
Sorry.
Item 22.
Item
22 is the petitioner states the file has been misplaced. Dismiss for non-prosecution with liberty to the petitioner to revive it as and when the file is placed. Yes.
23. 23, no instructions.
No instructions dismissed.
Item 24.
Item 24. The wife filed the affair since I did not marry her. In the meantime, we have already married and we have begotten a child and we are living the life very happily.
The affidavit of the second party. No, where is this
signature? This certificate is annexed to the marriage certificate at page 13.
You are appearing for the wife?
Yes, for the wife.
All right. Counsel appearing for the opposite party number 2 confirms that the parties have now been married and are living happily. She does not want to pursue the criminal case. In that view, the matter taken from the prayer clause and all proceedings consequent that hereby quashed.
Item number 25.
In item number 25, 26, 27, I'm appearing to EC. 25, 26, 27 are identical matters.
Yes, please.
I was just praying because I'm a little occupied with the Sri Jagannath temple matter, which is listed today before the honorables. I am appearing on behalf of the state. Your Lordship can accommodate me today only.
It's a 2CCC matter, sir.
Yes, my Lord. This is under the Payment of Wages Act. A criminal proceeding is initiated under the Payment of Wages Act. And apart from that, what is the complaint? Your Lordship will look at the complaint. The complaint says that the contractor disengaged them from service. The allegation is that the contractor disengaged them from service, and the SDJM takes cognizance against the principal employer. This matter requires some consideration. If Your Lordship will grant me 1 week time.
Tracking report, what is that?
I'm ready with the matter. I'm ready with the matter, but the only problem is...
No, neither AD nor...
This is under section 15(2) of the Payment of Wages Act.
No, have the opposite parties been served?
I think they have been served.
Registry has been asked to place a tracking report. Service of notice on opposite party number 2. None is appearing on his behalf. Interim order to continue in the interest of justice listed for the roster bench on 17 July.
Could your Lordships list it at the end of June, if it is possible?
Doesn't make a difference. Right.
So 25, 26, and 47.
Very
good. Item number 28.
None appears dismissed.
Item number 29.
Permitted to withdraw, my lords.
Dismiss is withdrawn.
Item number 30.
Permitted to withdraw, my lord.
All right. Dismiss is withdrawn.
Item number 31.
None appears dismissed.
Item number 32. Sorry, pardon me. 31 already taken. All of it. Item 32.
Dismissed. Not prosecution.
Item 33.
33, my lord. I am appearing for the petition, my lord. Here the criminal case has been filed for quashing of the proceeding on the ground of amicable settlement between the accused persons and the victim. Your Lordship, the victim herself appeared before the court below and sworn an affidavit before the Oath Commissioner, indicating that the matter has been amicably settled. And the offences involved herein are 294, 323, 354A, 354B, 506, and 34 IPC. My lord, because of the 294 IPC, the petitioner have to approach this honorable court because as per 320 of the CRPC, that is not a compoundable offence.
Where is her affidavit?
Affidavit is page 26, annexure 4. The victim herself.
So you want to confirm this? Counsel for the petitioner seeks to refer to the affidavit dated 24/11/2020 filed by the victim, stating that she does not want to proceed against the petitioners since none is appearing on her behalf. the concerned IIC will verify the genuineness of the said affidavit and file a report in this court before the next day. Paragraph list before the roster bench on 14th August. Interim order to continue.
My lord, may I pay one thing, my lord? In this case, after being charge sheeted summoned, we filed application before the trial court under section 205 and that has been rejected and appearance is fixed to day after tomorrow.
That is nothing.
I have filed an application for a stay of further proceeding.
No.
That will suffice, my lord.
No.
Till 14 August, your lordship can.
No. Yes.
Item number 34.
482 application will be sought, my lord. In item 33, my lord.
Yes.
Item 34.
Item 34, I am on VC below. Item 34.
Yes.
Yes. I know the impugned order in the annexure 5, page 20. The relevant parties in page 24. It is under challenge. Here in this case, the brief facts of the case is, Lord, the present petitioner is a director of a company, namely Hotel Chocolate at Kolkata. And his salary has been stopped by virtue of a letter issued by CBI. Also, may kindly see the letter dated 17/21
What is the main case about? What is the main case about?
Main case is, my lord, this present petitioner is the director of a company, namely Hotel Chocolate at Kolkata. And a CBI case is going against Rosebelly group of companies. And this petitioner company is a part of that company. But the petitioner is not party in that case. The petitioner, being a director, used to take salary from the hotel. And she is the mother of the chairman of the Rosebelly group of company against whom a CBI case is going in Bhubaneswar CBI. That's the fact of the case. But the
You have other sources of income, sir. You have other sources of income. Come to page 24.
Yes, but that has not been shown by CBI. I have absolutely no source of income. CBI has not annexed any document to that effect. And I am a cancer patient now. So I need to, at least my salary may be given. Now I'm a cancer patient. I'm suffering from gynecological problem. At the age of 70, my son is in custody since last 7 years. But that letter is not applicable to me at all because I am not a party in CBI.
No, but what was...
Only because I am the mother
You
of...
challenged the order dated 19/11/2020 passed by the Special Judge CBI, correct? That is what you're challenging here, sir.
Relevant fact not... Yes, sir.
You're challenging the 19th November order, correct?
Yes, sir.
What is wrong with that order, sir?
Lordship may kindly see page 24. On 2 grounds, my petition has been rejected. Page 24. First ground, the learned trial court held that the medical papers, doctors showed that the petitioner alleged to have been undergone treatment in private hospital. The treatment expenses is only 80,000. The petitioner has not filed any document of any government hospital. As the petitioner has got other source of income and petitioner has been inducted as a director of the company only after the arrest of the main accused and after initiation of the investigation. So the plea of the petitioner is not satisfactory. So I am a patient. I am bound to go to a government hospital. I am being under treatment in the private hospital. So that's not the ground on the part of the lawyer trial court to say only because I could not show any document of government hospital, I am not liable to take my salary. Second is, I was inducted as a director only after the arrest of my son. This ground cannot be, it's not possible.
So this 19, you challenged the order dated 19/11/2020. We are almost 2.5 years now. It has not come up even once. So clearly, petitioner is able to manage. This petition got listed on its own. This petition was listed on its own.
I'm explaining. In 2020, he was just the first stage of cancer. Now he's the last stage.
No. Today, if this matter got listed because on its own it has come up before the court.
Right.
You have not shown any interest in fact, pursuing this matter at all.
It was not listed because that's the reason. At least I need only my salary and nothing.
No.
It is around 2.5 lakhs.
The petition has been listed on its own today. The challenge the petition is to an order dated 19/11/2020 passed by the Special Judge CBI Bhubaneswar in TR case number 4 of 2017, whereby the request of the petitioner for release of medical expenses for treatment was rejected on the ground that the petitioner had otherwise sufficient means of income. Whereas on the other side, the thousands of investors were waiting for return of the monies given by them. Paragraph. Having heard and counsel the petitioner and having perused the impugn order of the trial court, Special Judge CBI Bhubaneswar, the court is not persuaded that any error has been committed by the said court in rejecting the request of the petitioner. Stop. Indeed, no document had been filed by the petitioner to support her plea.
Medical document.
After rejection of the petitioner's request for the impugn order would not come in the way of the petitioner renewing such request at an appropriate stage, provided there are sufficient materials to substantiate the averments in the application. The court is therefore not inclined to interfere, but with the above observations disposes of the petition. Yeah. You can break and have that. Yeah. We'll continue this bench after lunch.
Namaste, sir.
Namaste. Namaste.
Next item.
Orders item number 1, CMAPL 357 of 2023.
The case was dismissed for default on 27/2/2023.
All right. For the reasons stated therein, the application is allowed. And writ appeal 206 of 2018 is restored to the file. What is the main writ appeal about?
My lord, your lordship kindly see the writ appeal. The impugned order is page 13.
Yes.
My lord, your lordship will find there is no reason, nothing, no discussion is there. It is a valuable right of the petitioner.
It is seen that the impugned order was passed on the very first day of the writ petition and was also non-speaking one, since the case of the petitioner put forth was not even discussed. Paragraph. On that short ground, the impugned order is hereby set aside. And writ petition civil number 4343 of 2003 is restored to the file of the learned single judge, where it will be listed for hearing on.
My lord, the interim order passed there and may be restored.
September. I'm sending it back to the single judge.
My lord, there is imminent course of action. They have already deputed the police force to evict. And the interim order was passed in the writ petition on 34/2020.
All right, I'll restore it.
3.
All right, sir.
That your lordship.
All right. 25th September. The reply, if any, be filed. Was the reply filed in the writ petition?
In the writ petition, no reply is filed.
He filed in the petition not later than 4th September and rejoined that to any not later than 18th September. No further time will be granted for either party for that purpose. Paragraph. The interim order stated to be in favor of the petitioner will continue during the pendency of the writ petition.
That was passed on 34/2023.
34/2003.
That your lordship will find that
2003 will continue. All right. The writ appeal is disposed of.
Obliged.
Right.
Item number 35.
May it please, Your Lordship. Right here, the notice was issued earlier to the complainant. Item number 35 and 92 are connected matters, my lord. Here, peculiarity of the case is under annexure 3, my lord, the present petitioner, from the side of the present petitioners, the case was registered against the informant, a complainant in the present case for offences punishable under sections 498A, 307 to 94, 323. Well, that the address which is available in the complaint petition that I have given, my lord. Lingaraj Panda, shown up late, Srikara Panda, so and so, resident of village. One thing I was verifying, instead of Mallipara, it has been given Nalipara. That is perhaps the Malpara. Malpara, post is Malpara. Here the address, yes, my lord. Press notice. I'll file press requisites by Friday, my lord. The interim orders to continue. And my lord? My lord? 92. My lord. Interim order to continue.
Item 36. Item number 37. Item number 38. Item 39. Item number 40.
Beg your pardon, Lordship. Item number 40, I am from BC, my lord. Lordship, by virtue of the compromise which was affected between the petitioner and the opposite party number 2, which arose of the case on section. Lordship?
Come back with the remarks and then return to sender.
Yes, Lordship. 2 times the notices have been served upon the opposite party number 2, but it could not be even sufficient upon the opposite party number 2. So I humbly request before Lordship to dispose of the matter in view of B.S. Joshi versus State of Haryana, my lord. Because B.S. Joshi versus State of Haryana, as because the matter has amicably settled, Lordship.
No. Understand. The service is completed, it can't be done. It's better you go to the trial court. If she does not turn up, the trial court will know how to deal.
Lordship, may I request the Lordship to kindly have a glance to page number 20. Proceed further in this case. And the order sheet is also at page number 30, which is of the learned court below, my lord. When the summons have been served upon the opposite party number 2 times, but
they don't turn up, then the matter is found out that. That's far better, sir.
Lordship is not audible, Lordship. I'm sorry, my lord. Lordship, I am not audible, Lordship.
Despite notice having been sent to opposite party number 2, it has been returned unserved with the remarks left, returned to center. Paragraph. Without service of notice on respondent 2, it's not possible for this court to act on the affidavit and compromise petition, which has been enclosed as Annexure 4, and which, as pointed out by the petitioner, has been taken note of by the trial court already. Paragraph, leaving it open to the petitioner to point out the above facts at the appropriate stage before the trial court, the petition is disposed of. The interim order is vacated. Right.
41.
permitted to withdraw, my lord, with a liberty to file a better application.
Not better.
Because here is, my lord, a defect is pointed out that instead of filing a CLMP petition, my lord, I have a 482 application.
Whatever. So council petitioner seeks leave to withdraw the present petition. Dispose of its withdrawal. Right.
Item 42.
Permitted to withdraw, your lordship.
Dismiss this withdrawal.
Item 43.
43, my lord, notice service is not complete on the opposite party, my lord.
What's the matter about, sir?
There's an application under 482 of CRPC. We're challenging the order of cognizance, my lord.
A CST, all right. Permitting the petitioner to resolve.
No, my lord, if your lordship may kindly permit me, my lord, I'm relying on a judgment also, my lord. The sanction of the government has not been obtained here, my lord, because
at the appropriate stage you can raise all this, sir. All right.
Item 44.
Item 44, lordship, permitted to withdraw.
Dismisses withdrawal.
Item number 45.
Same order. Sorry, dismissed for non-prosecution.
Item number 46.
Same order.
Item 47.
Petitioner has raised all the points before the trial.
All right. Permitting the petition.
Yes. Item number 48.
None appeals dismissed.
49.
Petitioner raised all the points before.
All right. Permitting the petition.
Item 50.
None appeals dismissed.
Item number 51.
None appeals dismissed.
Item 52.
Same order.
53.
Same order.
Item 54.
Same order.
Item
May I please, lordship? The case is related to release of vehicle, my lord.
54, is it?
54, my lord. Auto was seized by the excise team, my lord. Allegation, my lord, of 560 kg of mahua flower was transported. Petitioner is not accused in this case, my lord. He is the owner of the vehicle. Another person, my lord, MD Aptas, who was transported the mahua flower, my lord. The vehicle was seized and the vehicle was inside the excise team, my lord, since long, my lord. 4 feet and petitioner was filed and same was rejected.
Page 13, your lordship may kindly see confiscation proceeding has already started, my lord. Therefore, the JMFC has.
But since when has it been seized, sir?
The vehicle was seized, my lord, on my lord, 12/7/2022, my lord.
Not even a year passed. So, which is the stage of the confiscation proceedings?
My lord, they are not intimating to the petitioner, my lord, where the confiscation proceeding initiated. Notice has not been served to the petitioner, my lord.
Where is it pending?
My lord, it is pending before the authorized officer, but it has been reflected in the order of the learned JMFC.
No, where authorized officer means which date? Is there no date?
Yes, my lord.
You better find out, sir. Counsel for the state
I'll take instruction, my lord.
Submits that the confiscation proceedings have already commenced and are pending before the authorized officer. By the next date, he will inform the current status of the said confiscation proceedings and the next date on which it is listed before the authorized officer.
Date, my lord.
List on 18th May. Before the roster batch.
Item number 55.
None appeals.
Item 56.
Item 56, my lord, permitted to raise all the points before.
All right, permitting the petitioner to raise all, please. Right.
Item 57.
May I please, lords? My lord, the petitioner has filed the above miscase to quash the affair which is pending before the POSCO court at Canada, my lord. My lord, in the meantime, my lord, the petitioner has already married to the victim and out of their wedlock, a female child has been born. My lord, kindly see Annexure 2, my lord, page 14, my lord. And beside that, they have the victim and her mother has shown an affidavit that they are not willing to proceed the case, my lord.
And I am appearing for the victim as well as the informant. The matter is already settled. And now they are living together and there is a small child.
All right. Counsel, the opposite party number 2 states that the petitioner and she have married and they also have a daughter.
Yes, madam.
That we have matter take from the prayer clause and all proceedings consequent thereto hereby quashed.
58.
I has been filed, miscase.
57.
57. You were in 57 or 58?
57.
We have finished 57. Is over.
Item 58.
None of this dismissed.
Item 59.
None of this dismissed.
Item number 60.
Same order.
61.
The memo taken into court. Dismissed.
Item number 62.
Maybe. Here, my lord, the petitioner is an employee of a finance company, my lord. My lord, when he was visited the house of the informant, he was assaulted and annexure 1 by the annexure 1 or the FIR was lodged by the petition. Thereafter, my lord, to counter this FIR, my lord, when annexure 2, this FIR has been registered, and to quash this proceeding, my lord, I filed this application under 482 service. In this context, your lordship may have trying to have a glance to judgment of the Honorable Apex Court, my lord.
62.
62.
My lord, Charanjit Singh Chadha case, my lord, the Honorable Apex Court has been pleased to hold. My lord, these are civil disputes and criminal, if criminal angles are given to it, my lord, this would amount to abuse of the process of the court, my lord. A paragraph, your lordship may kindly have a glance at judgment paragraph 15.6.17.
Yes.
So therefore, my lord, since the financer being the owner of the vehicle, my lord,
yes,
if they are entitled to take possession of the vehicle, so therefore no offense can be made out against them, my lord. Relying on this judgment, my lord, Patna High Court judgment, another judgment I have also relied upon.
Charge sheet has been filed on 27/9/2018.
Right. We permit you to raise all, please, sir. Permitting the petitioner to raise all, please. You can give this back at the appropriate stage in the trial court. The petition is disposed of. All right.
Item 63.
May I please?
None of this dismissed.
May I please? 63. Here the petitioners have been granted with the anticipatory bail under annexure 4, but they could not avail the same. Now summons have been issued for appearance. They apprehend that on their surrendering they may be taken to custody. They have granted with the anticipatory bail but could not avail the appearance. The annexure 4.
Not inclined, sir.
Kindly, my lord.
Not inclined.
They will surrender, my lord. That may be considered by the trial court, my lord. That is
not inclined, sir. NBW is issued in which year?
No, not NBW issued, my lord. Summons have been issued, my lord.
When?
No. That is 7/2/23, my lord, on by 22/3/23 for their appearance. Page 19, order dated 7/2/2023, my lord. They have filed their vakalatnama through their advocate. 22 March.
Only for appearance it has been put up. On what happened on 22nd March?
That instruction I don't have.
Got it. What do you want to do? Want to withdraw?
Permission may be granted to surrender, my lord.
Not inclined, sir. What do you want to do?
Lordship may pass it.
All right. Counsel to the petitioner seeks a relief of permitting the petitioner to surrender and then apply for bail. Given the history of the case, the court is not inclined to pass such an order. The petition is dismissed.
Okay.
Item 64.
None of this is
65.
Put the prayer clause. Memo taken again. Prayer clause dismissed.
Item number 66.
66, may I please, your lordship? My lord, may I pray for an adjournment, my lord, to remove the defects, my lord?
No. Tell us what it is.
My lord, I have filed an application under section 482 of CRPC, my lord, for quashing of the criminal proceeding, basing on, my lord, amicable settlement between the parties, my lord.
376,
my lord, to that effect, if your lordship pleases, my lord, I may be permitted to satisfy this honorable court by relying on judgments by the Apex Court as well as other high courts, my lord. And my lord, the same has also been observed in the while granting of the bail. Your lordship may have a glance to running page number
Bail
30.
is different, sir. Quashing is different.
My lord, for quashing, my lord, I'm relying on the judgment of my lord, the recent Karnataka High Court judgment between Sri Satish K versus my lord, State of Karnataka in criminal petition 4172 of 2022. If your lordship pleases, may I read the relevant portion, my lord?
Yes.
In light of the judgments rendered by the Apex Court, this court and that of Delhi High Court, which requires to be noticed, is the closure of proceeding on account of settlement arrived between the parties, even for offence punishable under section 376 of IPC, is permissible. Therefore, the affidavit of complaint filed along with the application invoking section 320 of the CRPC read as follows, my lord.
No affidavit anyway here.
My lord?
Where is the affidavit here?
My lord, to that effect, if your lordship pleases, my lord, my lord, I may be permitted to rely on another judgment, my lord.
There is no affidavit as of today. What's the point of relying on those judgments?
My lord,
As of
the
today,
next-
there is no affidavit, sir. Sorry. If you had filed it with the affidavit, still I don't know whether I would have considered, but without the affidavit, no.
My lord, your lordship may keep it to any date in this week only, my lord. I'll file an affidavit. my lord.
Counsel, the petitioner seeks leave to withdraw the present petition at this stage, with liberty to seek appropriate remedies in accordance with law. This post office withdrawn with liberty is paid for. All right.
67.
67, my lord. I filed another application on the basis of amicable settlement, my lord. This is out of a matrimonial discord, my lord. And the matrimonial relationship between the parties has already been snapped by decree of divorce, my lord. And the compromise petition is also annexed, as your lordship may have a glance to.
Have you made it a party?
My lord? Yes, my lord. I have made the
husband a party.
Husband a party, my lord.
This is the wife asking for quashing.
Yes, my lord.
How does it happen?
My lord, there has been a criminal case which has been also initiated as against the wife, my lord.
Very strange. Or a notice returnable before the roster bench on 4th July. Yes.
Item 68.
Grateful, my lord.
Wait, please, your lordship. I'm appearing through facing. Item number 68, my lord.
Yes, please.
Your lordship, similar matter, your lordship adjourned. That is CRLMC number 1485 of 2023, your lordship. Same point of law.
Where is it coming up? When is it listed, sir?
Sir, listed on 10th July of 2023.
All right. List along with CRLMC
1485.
2023 on
10th July.
10th July of 2023.
For the roster bench, yeah.
Grateful, your lordship.
Item 69.
The application is filed for restoration of the original CRLMC.
What is that original CRLMC about?
CRLMC was filed by the husband. Ultimately, husband earlier accused in a case. For quashing of the case, it is filed. A fair quashing. Wife has given affidavit. Subsequently, the girl married to this boy.
I am for the victim.
All right. Counsel appearing for the opposite party number 2 confirms that the petitioner and
opposite party number 3. Opposite party number 3.
3. Yeah. That the petitioner and opposite party 3 have married and are living happily together. And a baby child also. A son is also there.
With a son.
And are blessed with a son. All right. In that view, the matter take from the prayer clause and all proceedings consequent thereto hereby quashed.
Item number 70.
Item 70, I am on BC, my lord.
Yes.
I am appearing on behalf of Mr. Bhuya. As he is seriously ill, my lord, I am praying for an adjournment.
No. Tell us what the matter is.
I am not aware about the facts of the case, my lord.
That's all right, sir. Permitting the petitioner to raise all please the proper states petitions.
My lord, kindly be adjourned to him.
It's all right. It's all right.
At note 7. Item number 72.
None appears dismissed.
Item 73.
Same order.
74.
Same order.
Item number 75.
Item number 75 permitted to withdraw, madam.
Dismiss is withdrawn.
Item number 76.
76, 77. First thing actually I would like to say the final form has already been given.
I see.
A false case. And besides that, the company has not been made a party. Tata Steel.
Oh,
I have given the judgment.
all right. Same one. You just have to change those details. All right. Same one.
76, 77.
77. All right. Good.
Item number 78.
None of this dismissed.
Item 79. Memos.
Memo taken on record. Dismissed for now. Not addressed. Infructuous.
Item number 80.
Item 80, my lord. Question of jurisdiction has been raised. The cause of action is.
My lord, in item number 79, my lord, interim order may be vacated, my lord. There is interim order, my lord. And it is
Obviously, sir. Interim order. Not.
Lord,
80.
the affair has been lodged at Bhubaneswar. So the cause of action arose at the West Bengal. The dispute between the marital dispute and consummation is at Kolkata. I have filed an application challenging that cognizance order before the learned session judge. Keeping in the view of your lordships that judgment of the Y. Abraham case versus Inspector of Chennai reported in 2004, I have given the citation, my lord, at flag B before my lord. Where at paragraph 15 and 18, the Honorable Supreme Court has that the cause of action is the most important. Where the entire affair shows the cause of action is at West Bengal. And keeping the view of that Y. Abraham's case, my lord, our Honorable High Court in 2006.
Where does she live, sir? Where does the wife live?
Wife residing at West Bengal, my lord.
Wife residing in West Bengal or you people residing?
No. Both of us are residing at West Bengal. Marital dispute at West Bengal. Wife residing at West Bengal. And is working in Accentures.
Where is she a party? She's not made a party.
Her father was made a party because the informant was father, not the wife. And the notice has been issued to the wife, informant also by this Honorable Court, my lord, on dated 3/3/2021.
Where is that, sir? Which matter is that? Criminal MC?
Pardon?
You were mentioning a certain matter and an order passed by this court.
Yes, that is on 3/3/2021 in this case, my lord.
No. What's this service report?
After service.
Notice was issued to the informant.
Yes.
Issued after personal service.
Stay of the further proceedings and put up on 22/4/2021. And the latest judgment of the Honorable Supreme Court also in the 2008, that is in your lordship Prem Kumar and others versus State of Kerala, where the Honorable Supreme Court has taken note of that cause of action at paragraph 14, your lordship. I am passing that judgment. Apart from the other citations at flag B, the lordship on to page 9 at paragraph 13, so far the jurisdiction of cadaver police stations vis-a-vis the provision of 177 CRPC is concerned. We may notice that in Y. Abraham Ajit versus Inspector of Police Chennai, reported in so and so under section 498A 406 and section all the crimes in local.
The cause title of your petition, it has only one respondent.
A respondent.
Opposite party is only one.
No, my lord. I have filed the consolidated cause title where the opposite partner 2 is there, the father, Manoranjan Kara, son of Dambarudhar Kara, plot number so and so, Bhubaneswar.
One but one. Where are you reading?
Pardon?
Where is opposite party number 2 made a party?
In a consolidated cause title, your lordship can listen.
Where is that?
Consolidated cause title.
Where is consolidated?
Yeah.
It is contended that both the opposite party number 2. But the address given for opposite party to number 2 is not West Bengal.
At Bhubaneswar, my lord. He is residing at Bhubaneswar. OP number father is residing at Bhubaneswar. But the wife is residing at Kolkata. Cause of action is entire at Kolkata. But father has lodged here only. She could have lost the affair because the and your lordship also in 2006 volume 2 OLR page 128 at paragraph 8 and 10.
But even all this can be raised, sir. Can be raised before the court at the appropriate stage.
Your lordship is correct to that, but so far the jurisdiction is concerned, the Honorable Supreme Court has said it can be transferred. In that case, your lordship, I have just passed, but just passed that Prem Kumar's case. But now the question is, the root of the cause is that where the cause of action arose. Why Abraham's case, vis-a-vis that Bhattacharya case, your lordship, and Asit Bhattacharya versus Hanuman Prasad Oza, 2007 volume 7 scale, my lord, I have passed that judgment. Where also the Honorable Supreme Court held that no, if the cause of action is there, then trial should be made at there.
What is the stage of the trial now?
The trial has been stayed. There is no trial at all.
What is the service of notice position? It is seen that the service report states that valid service was effected upon opposite party number 2. He is, however, not present in court. Paragraph. Counsel for the petitioner relies on the judgment of the Supreme Court dated 19 December 2008. So there's no citation for this.
It has not been.
Criminal appeal number 2088 of 2008, bracket Prem Kumar, State of Kerala, where jurisdiction was lack of jurisdiction of a certain court for taking cognizance was the basis for quashing the criminal case. Paragraph. Here it is seen that all the petitioners are residents of West Bengal, whereas the informant that is opposite party number 2. Has filed a complaint in Bhubaneswar. It is pointed out that all cause of action arose only in Calcutta and not anywhere in Orissa. So this is not even contested by opposite party number 2. The court accepts the prayer of the petitioner and quashes CT case number 451 of 2018 and all orders and proceedings consequent thereto. Correspondingly, the order dated 9/12/2020 by the learned session judge Khurdan, criminal division number 87 of 2020. And the order dated 30th August 2019 of the SDJM Bhubaneswar in CT case number 4517 of 2018 are hereby set aside. The CRMC is disposed of.
Item number 81.
May it please, Your Lordship. I am through BC, my lord. Your Lordship, the item number 81, my lord. Your Lordship may kindly peruse order dated 9th September of 2021, wherein Honorable Court observed learned counsel for the petitioner seeks some time for amendment of the petition, Your Lordship. And thereafter, Your Lordship, I filed the amendment cause title, so also the amendment prayer, Your Lordship. Now, Your Lordship, on behalf of opposite party number 4, the learned counsel, Mr. Thakur, is appearing, and they are saying they didn't want to continue with the main criminal case, Your Lordship.
Yes, Mr. Thakur.
Previously, Your Lordship, they said
Yes, Mr. Thakur.
My lord, I am appearing for the OP number 4's father.
Yes.
He is the TT Mahanand.
What do you say, sir?
I am appearing for the father of the OP.
Do you have any submission to make?
Sir. My lord, in this case, the development is that the OP number 4 has been married and she is now living with her matrimonial house peacefully and do not want to proceed in this case.
Counsel to opposite party number 4 states that she is now married and residing peacefully and does not wish to pursue the case against the petitioners. Paragraph in that view of the matter, taken from the prayer clause and all proceedings consequent that were hereby quashed.
Item 82.
Gratefully, Your Lordship.
May I please, Your Lordship? 2 months prior to the registration of the FIR, a CRMP was filed by the informant as petitioner number 1 and principal co-accuser as petitioner number 2 for seeking protection from honor killing as the parents of the informant wanted to lodge false case against the petitioner and take any extreme step against them. Thereafter, after that, this FIR is being registered against these petitioners are all relative of the principal co-accused person. Nothing specific is being attributed to them. So the false case.
Permitting the petitioner to raise all piece of paper.
Yes. Item 83.
None of this dismissed.
Item number 84.
Item number 84, my lord. My lord, in this case, at that time I have challenged the order taking cognizance. Offences 506 and 507 of IPC, your lordship. Presently, trial has been progressed. All the witnesses have been examined, but deliberately the IO is not appearing for last 4 months, your lordship. Last date also on 6th May, but IO has not appeared. Repeated summons were going, but in spite of that repeated summons, the London
prayer is something else, sir.
No, at that time I have challenged the order taking cognizance. I am saying before my lord, but presently the present position of the case.
Proceedings. As far as this petition is
concerned, small prayer is there, your lordship. Lordship may kindly target the case so that it will be
permitting the petitioner to raise all pleas if the appropriate stage petitions.
Because it is trial is at flag end, your lordship.
Request the trial court to expedite the conclusion of the trial.
Lordship, may I play one thing, Lordship? Lordship may pick up on to appear the IO any date on the month of June, your lordship.
That's not the prayer, sir. All right.
Item 85.
Sorry for the intervention, my lord. Your lordship, in item number 81, the matter urgent. I can't hear your lordship.
Squash, sir.
Grateful, your lordship.
Item 85.
None of this.
Opposite party number 2. Item 86.
85, I am for the opposite party number 2.
All right. None of this is the petitioner. All right.
But against which order this application was filed?
Dismiss for non-prosecution.
Yes. 86.
Item 86, your lordship has posted identical matter to 24 July before the roster bench ballot. Only interim order to continue matter.
Interim order to continue.
Grateful.
Item 87.
Lord, 87, the wife before my lord against the has lodged the affair under Annexure 3 First, that is registered as FIR number 23, dated 14/3/19, against the husband, that is 498A, 323, 506, and 34. To counterblast the same, my lord, mother of the husband has filed an application FIR, that is annexure 1, against the wife, I mean daughter-in-law and sister. Your lordship has noted that Eicher structures case, where the Honorable Supreme Court had take note of that judgment and held that there cannot be any FIR to counterblast the FIR, and to your lordship may kindly see that parameters has been fixed by the Honorable Supreme Court.
All this is later stage, sir, not on the 482 stage.
Pardon?
Later stage, not here, not 482.
That is there. They have the Honorable Supreme Court to hold that only to the factual scenario as noted. Proceeding were initiated as a counterpart.
You're not appearing in the companion one.
Pardon?
Which one are you appearing?
I am appearing in CT 1215 of 2000. That is Annexure 3. Annexure 3 is my affair.
1 minute, sir. In item 87, there are two matters.
Yes, first and second, both the matters.
You're in both?
Both matters.
How come both are filed?
Both, I mean, my lord, that wife and mother has filed. Subsequent item that the brother has filed.
No, Manoranjan is who?
My brother.
Manoranjan
is my brother. And I have filed, that is, I am the wife of Jasavanta who has lost the affair. Because of the torture and mishandling, I have filed an application FIR under Annexure 3 for the first. In order to counterblast the same, my mother-in-law has lost the affair under Annexure 1.
All right, permitting both, in both matters, you say permitting the petitioner to raise all pleas at the appropriate stations. Right.
Item number 88.
May I pray one thing? Both the matter may kindly be disposed of. That.
Yeah, both.
Yeah.
Item number 88.
None of this.
89.
Please, Lord, my Lord, I have filed this case for quashing of the cognizance order. This case arises out of complaint case. The fact of the case is like this. The OP number 2 filed a complaint case against the present petitioner, who is the mother-in-law and brother-in-law. Now, and the local police and the magistrate sent it for under section 156(3) of CRPC. Thereafter, the magistrate took cognizance for the offence against the petitioners under section 498A, 406 and 4 DP Act. Now the status is that the OP number 2 is now with her husband.
Where is that affidavit?
Affidavit, my lord. I have, my lord, I have filed a Chuktinama by the, that is Annexure 4.
No.
That is Annexure in Oriya.
That is not good enough.
My lord.
This kind of compromise is not a good enough compromise.
Now the both OP number 2 and her husband.
You have to produce an affidavit for that.
My lord.
It is claimed that opposite party number 2 is living happily with her husband.
My lord, one thing, my lord, there is civil litigation between the petitioner number 2 and her elder brother, the husband of the OP number 2. Due to this civil litigation, the OP number 2 may not turn up. I apprehend. Then if my lord will direct, I will file the affidavit. Now the status is both husband and wife, the OP number 2 and her husband are leading their conjugal life. By the interference of local gentries.
It is claimed that opposite party number 2 has married petitioner number 2.
No. His elder brother, Arjun Patra. Cognizance has been taken against D. Arjun Patra. who has not approached this honorable court. Cognizance order is under Annexure 4, Annexure 1, that is at page 14. My lord, got it? D. Arjun Patra.
No. You come to the cause title now.
Cause title, both mother and younger son has approached. His elder brother is D. Arjun Patra, the husband of the OP number 2.
Why is he not made a party?
Elder brother.
Whoever is the husband, madam.
D. Arjun Patra, the husband of OP number 2.
Why has he not been made a party?
I will make party. That D. Arjun Patra is not cooperating. Why?
Can't keep out a person who's not cooperating, then obviously there's no case for quashing then.
Both the petitioner number 1 and 2, they are innocent. Their petitioner number 1 is the mother-in-law. 2 is the brother-in-law of OP number 2.
It is claimed that opposite party number 2 is living happily with the son of opposite party, petitioner number 1.
Number 1, elder son.
However, there is no affidavit as such placed on record. Counsel for the petitioners needs time for that purpose. List before the roster bench on 16th August.
All right. Beg pardon to make a mention, my lord. I'm sorry.
16th. This month.
16th August.
Sorry, man.
Item number 90.
Pardon, my lord, I'm on VC, my lord. My lord, parties are going to reach at a settlement, my lord. My lord, previously there was another dispute relating to this dispute. Pardon, my lord, I mean VC, my lord. Item number 90, my lord.
Yes.
My lord, parties are going to reach at a settlement, my lord. My lord, previously there was another dispute relating to this dispute, wherein settlement has also been reached at annexure number 2, my lord.
That's all handwritten, sir.
My lord, may allow 2 weeks time to file an affidavit, my lord.
You file a petition after you get the affidavit, sir, not before.
My lord, opposite party are present, my lord.
Present, your opposite party.
I have no instruction, my lord. I will take instruction. If he is saying that, I will take instruction.
All right. Counsel petitioner claims there is a compromise between the petitioners and opposite party number 2. Counsel for opposite party number 2 needs time for instructions.
My lord, item number 96 also same.
Let's start this for the roster bench. July 25th.
My lord, item number 96 also same, my lord.
All right.
Item 91. Item number 93.
May I please your lordship? My lord, this is a classic case of excessive exercise of authoritative power by the police, your lordship. My lord, the petitioner has been made a scapegoat to pass on the crime of somebody else to him, your lordship. On 11th November 2020, a raid takes place on the petitioner's house. A seizure list is prepared, which is there, your lordship would peruse at page number 19, your lordship. There, it is clearly that seizure list has been prepared on the spot with the signature of local witnesses present. Your lordship, there is no mention of a bear skin being seized, your lordship. But later, the petitioner is taken to the headquarters 45 kilometers away. A new seizure list is prepared, and where a blatant lie is said that there is nobody of the villagers refused to sign the seizure list, and there a bear skin has been included, and the proceeding has been initiated on that FIR, your lordship. And on that, your lord, this honorable court had directed to get instruction to the opposite parties, to the government.
Yes.
At page 13, your lordship may kindly see the instruction has not been received, but your lordship may kindly see page 13. My lord,
nature of offense and facts of the case. Sir, as per instruction of range officer, I went with range officer and staff of Patra range and mobile staff of staff of division office for house.
So you have to take instructions.
Instruction, my lord, that has not been received. My lord.
Counsel for the state still wants time for some instructions as a last opportunity in the interest of justice. List on 2nd July.
My lord, there is an IF for,
No, 3rd July.
my lord, there is an IF for staying the proceeding and the learning.
Sorry, just say notice.
Pardon,
92 skip your lordship.
94.
94, my lord, pray for raise these points with the court below, my lord.
All right, permitting the petitioner resolve, please.
Item 95.
Item 95, your lordship's liberty may kindly be granted to raise all the please.
All right.
Item number 97.
Item 97. I am in
for the opinion number 2, my lord.
I am in VC, my lord. With your lordship's permission, may I address your lordship through VC, my lord?
Yes.
Here impugned is, my lord, order taking cognizance. Normally, I would have prayed your lordship to consider my case and allow me to file a discharge petition. But your lordship may kindly have a glance to page 50, last paragraph. Your lordship got it?
1 minute. Yes.
In fact, I am a government official. My plea is that sanction was not taken. Now, my lord, at the stage of cognizance, he has, my lord, come to a finding that, can I read the paragraph, my lord?
I've read it, sir.
That no sanction is required. My lord, then what is there left to be decided in a trial or at the stage of framing charge, my lord?
Yes.
Because he doesn't have a power to review his own order. I cannot raise this plea at the time of framing charge.
Lordship, see page 49. The order of cognizance.
Yes.
Starting from the, I'm reading, my lord, permitted to read, my lord. In continuance of the above order, the case record is put up today. There is the complaint petition, initial statement of complaint, and 202 inquiry. I found there is a prima facie material for the offence punishable under section 355, 294, 506 IPC to proceed against the accused. But the question is whether the sanction is required to proceed against the accused as is a government employee, that is Tahsildar. It is better to refer the judgment pronounced by Honorable Apex Court in Ganesh Chandra Jio versus State of Orissa 2004-8 SEC 40, where it has been held that in order to extend the protection given to the public servant under section 197 CRPC, it is to be seen as to whether the alleged act committed by the public servant is reasonably connected with the discharge of his official duty. At the same time, if the public servant is under any obligation to do certain act and he omitted or neglected to do the same, he cannot claim privilege. The sanction has thus to be construed strictly while determining its applicability to any act or omission in course of service. Its operation has to be limited to those duties which are discharged in course of duty. But once any act or omission has been found to have been committed, my solution is that the act or the act committed by the accused is not with the discharge of public duty, as revealed from the complaint. My lordship, here is my complaint petition, my lord. So sanction, if he has committed the act in discharge of his public duty, then sanction is required.
So, Mr. Monty, even that can be gone into.
My lord, the decision relied upon by the learned trial court, my lord. Your lordship may kindly see the language. But once any act or omission has been found to have been committed, my lord, my prayer is, my lord, if this is the finding of the court at the stage of cognizance, what is there left to be decided in the trial?
It's not a finding, sir. The problem is in treating it as a finding.
Lordship, kindly glance to page 38, the complaint petition. the manner in which the accused is committed. It is not no way nexus with discharge of public duty.
I was a
So the sanction is not
quasi-judicial-
required.
I was in a bench dealing with quasi-judicial proceedings. He was the lawyer. He inquired about some cases without filing vakalatnama, which I objected.
No, my lord. Lordship can page 38, my lord. The facts I have written in the complaint
But even the entire records of these proceedings,
Lordship,
Lordship,
page 38.
the petitioner therein is the witness in the complaint petition. That will show the nexus.
Lordship, page 38, the complaint, the averments, the facts of the complaint, my lord. The complainant is an advocate on 25/7/16 at about 3:45 p.m. The complainant had been to the office of Revenue Inspector Sonpur to inquire about his pending mutation cases. During his discussion with the RI Sonpur, the accused suddenly came inside the RI office. He came from his chamber to the office of the RI and misbehaved to the complainant by using objectionable words, saying nonsense, get out from the office. The complainant protested the incident behavior of the accused, but the accused became angry and he rushed towards the complainant and shown gesture to assault the complainant by showing first blow. He also threatened the complainant to put him behind the bar by lodging false case against him. Thereafter, out of fear, the complainant left the office of Revenue Inspector Sonpur. My lord, entire story that the accused has done the offense in connection with his discharge of public duty. He came out from his chamber, went to the chamber of the Revenue Inspector, thereafter suddenly abused. So, my lord, the sanction is not required. And I am relying the judgment, my lord.
So this can also be argued in the trial court.
Unless this finding goes, my lord, if
No, the finding, the order taking cognizance.
Lordship, I am relying the
As
judgment
regards
in that regard.
need for sanction need not be treated as a final determination.
Lordship, I am relying the judgment. AIR 760.
Cited before the court. The plea is therefore allowed to be raised at the stage of charge. Charge sheet has already been filed.
My lord,
Yes,
it's a complaint case. It is a complaint.
All right.
I can raise this plea irrespective of the finding, my lord, your lordship.
Right. That's what I've said.
Grateful. my lord.
Therefore, such plea can be raised at the appropriate stage, irrespective of the observations in the impute order. The petition is disposed of.
My name may be recorded.
All right.
Item 98.
The order taking cognizance was in challenge, my lord. In the meantime, the case has been posted for framing of charge. I can agitate those points.
Correct. Permitting the petitioner to raise all pleas in the appropriate stage.
Are they at the time of framing of charge?
Or
Item number 99.
I may be pardoned. With great respect, I may be pardoned, my lord. Item 70 can be heard in the next date. For that reason, I need an adjournment, my lord.
what's this item?
Item 70.
70.
What is it in 70?
My lord, my learned senior is ill, so I pray for an adjournment.
No. What is the matter about? Tell us. Yeah, one Mr. Thakur was there in item 70. All right.
Yes, my lord. I pray for an adjournment. This is my sincere approach.
The one Mr. Thakur has already appeared in item 70. Sir.
So, yes, my lord.
Yes. That order is over, sir. Yes.
My lord, kindly, I pray for an adjournment.
May I pray, your lordship?
Item 99.
The petitioner is the principal of Jawaharlal Nehru Navodaya Vidyalaya, and as principal, he received several complaints from the students of the 11th and 12th girls students regarding some action that their photography is being shown in the social media by a teacher. So, based on that complaint, the authority decided to initiate a disciplinary authority, and pending the disciplinary authority on administrative grounds, he was transferred.
Right.
And based on the direction of the authority, I, as a principal, filed the caveat. Now, she happens to be the wife of a middle level DSP, and because of this, my lord, this complaint has been filed, and is the entire complaint, there is absolutely nothing has been there. The complaint say that why I filed the caveat, why there is a your lordship kindly talk to that complaint. And the government has been directed twice by this lordship to apprise the court about the latest position.
Yes, ma'am. Well, Yes, my lord, the case is pending for examination of other independent witnesses and obtaining caste particular from
All right.
circle officer.
What do you wish to do, sir?
No, my lord, I'm just telling the Lordship kindly visualize that I'm an officer. Once this is there, Lordship kindly have that complaint itself. Once your Lordship go through complaint, I have nothing to say. Lordship kindly have that complaint.
Which page is this?
My lord, page
23.
18. It started from page 16. Page 18 is the
18.
Yes. How all these offences which has been placed made? Lordship kindly have that.
Sorry?
Lordship kindly have that complaint. I'm placing it. You know.
So which page? You tell us which page.
Page 18, my lord.
Yes, I have it.
Your Lordship. May I please, my lord?
Yes, please.
Yes, ma'am. With regard to the, I humbly submit that Mr. Ranjita Senapati, a regular employee of Navodaya Vidyalaya Samiti, is constrained to bring to your benign attention the following facts of kind considerations and rendering justice to the scheduled caste woman. The employee being sexually harassed and mentally oppressed unnecessarily by the principal Ramraj Singh, the petitioner. I joined TZT in 1998, Navodaya Vidyalaya Samiti, and Nuapada, Odisha, and worked sincerely and honestly till 2003. I was transferred to JNB Mundali, Cuttack, Odisha in 2003 on spouse ground. I performed my duty efficiently with the devotion and sincerity for all development of education and all the students of school without remarks by any authority. But after joining up new principal, Ramraj Singh, I am facing a lot of harassment and victimization unnecessarily, subject to mental operations, and every now and then. The principal has also a habit of derogatory and casteist remarks. That while the important board examination has commenced from 20th February 2020, I was teaching the English and 10th class student, and there were a shortage of teacher. I was transferred all on a student to Navodaya Leadership Institute, Konark, Puri, on the ground of administrative exigency, while letter number so and so, followed by a caveat petition which was filed by the principal in the Court of Central Administrative Tribunal bench on 14/2/2020, so as to deprive me from justice if this court, if any firm, the court which is indicated deliberately intention behind it. I have been instructed by Deputy Commission. The next thing, it's a matter of regret that even after absence of sanction post, I have been intentionally attached to NLI Konark Puri for to deprive me from mental place and so on. So what, in obedience to the order and as a duty-bound employee, I have joined the new assignment. That the details of harassment made to me as vindicated in the actions made by the Ramraj Singh are as follows. That being well aware of the fact that I was a child care leave in 2017-18, the principal Ramraj Singh Jain Mundali Cuttack, with vindictive attitude and ulterior motive, passed an adverse remarks on my performance in APAR. Well, these are FIR under section 3. And I had to receive explanation from Deputy Commission NBC the Bhopal. It is also relevant to point out here that in the period of childcare leave during which the adverse remark was passed in APAR, salary was drawn by the school in excess of the income tax, and also the excess 26,000 deducted remain to be refunded till now. The excess amount of leave salary drawn was recovered from my account subsequently. That I was allotted with a new quarter by ex-principal M. Mariappan, but the possession of the quarter could not be taken by me immediately, owing to renovation work of the quarter was under the progress. After joining of the new principal Ramraj Singh, he forced me to forego the allotment and deprived me from shifting the quarter to on the ground of false allegation of cutting the tree in the premises. He even closed the way of all sides of the quarter forcibly, only to harass me, and had personally Mr. Prabhati Pradhan, AC cluster, and so and so, so and so. In nutshell, there is absolutely no allegation of the harassment, and there is nothing in the affair that it was that I belongs to the. In this regard, I have judgment.
Yes. Bhajan Lal.
Bhajan Lal.
Don't read all this now, please.
No, I'm not reading, my lord. I'm not reading, but I'm confining myself to this, that 102 paragraph. That's absolutely malafide institutions of the affair. Now let's come to that directly on that.
Lord, since this is an internal dispute between the principal and the other staff, my lord.
Only that staff, not other. How can a function? It is very difficult if somebody makes a affair only because I initiated a disciplinary action and I have shown your lordship that annexure 3. Kindly see the grown-up girls have what they have written as a complaint. I was compelled to initiate the action. And I am doing everything under the directions of the higher authority. The higher authority asks me to file caveat. I am filing caveat. I have annexed that document. I have annexed that document, my lord, that has, and not a single word on that. Only things that one is that adverse remark in APR. That's a fallout of the proceeding. But all these things which you have done. Lordship, kindly that annexure 3 series, your lordship, once all these the grown-up girls have been taken, their photograph has been taken, shared in the. I as a principal am responsible, and I therefore he has been put to explanation, and I have intimated to the higher authority. Higher authority also asks her to file the intimation. He herself write in the complaint.
Not inclined, sir.
Lordship, I am placing this judgment on Lordship.
All right. All the judgments you want to read?
Hello?
You want to read all the judgments?
Hello? No. Yes, Malad.
Yes.
Malad.
I don't have time for you to read all the judgments, sir.
No, I'm not. I'm not reading, Malad.
You want me to pass a long judgment?
No,
we'll discuss all the matters dismissed. I'll pass a detailed judgment.
Now, so far the connected matter is concerned, even that is not there. The connected matter, the only allegation is that he made some complaint against the petitioner in the connected matter. That was not inquired into by the first petitioner. And therefore she has been tagged.
All right.
That is the only, even the entire affair, there is no allegation against the second petitioner.
What is her position, the institution?
Well, she was a teacher in that school. She has already retired in the meantime.
What is your position, sir?
I'm the principal.
No. The informant is not made a party.
Informant is made party.
Who is appearing for the informant? In fact, in the first matter, who is appearing?
Hello? The connected matter is 1842.
Who's appearing, sir, for the
informant? Senior Sujata Jena.
Where is she?
And is not.
Where is she? It is seen that Ms. Sujata Jena is appearing for the opposite party number 2 in both these matters. Put both these together. Today, somehow, she is not present. The registry will inform her to remain present on the next date. There's an interim order, sir.
In the second matter, not in the first.
All right. Just say the second matter, you say interim order to continue. The first, you say let's go for the roster on 14th August.
I take pardon, my lord. Item number 72, my lord. My lord, item number 72.
1 minute, sir.
Item number 100, please.
May I please? I'm challenging the entire proceeding on the ground of acquittal of the co-accused person.
That's okay. You can point that out, sir. Permitting the petitioner to raise all pleas in the appropriate stage.
Item 72.
Pardon to mention, my lord.
Item 72, my lord.
Yes.
My lord, here I have challenged the proceeding, my lord.
What's the order?
My lord, I will just take your lordship's kind attention to one paragraph.
Yes.
Of the judgment passed by the learned lower court, where he has already found that there is no connection of this petitioner in the alleged crime. My lord, your lordship may kindly come to page 57. My lord, the allegation is under section 307 120B, my lord. So far as I am is concerned, my client is concerned, he is implicated under section 120B, my lord. And that is admittedly on the face of record, my lord. I'll just take your lordship's kind attention to page 57, my lord.
Yes.
Lordship got it, my lord.
Yes.
I'm just reading out, my lord, this small portion. The disclosure can be construed as voluntary. On the other hand, as discussed above, same is a weak piece of evidence and hence cannot be acted upon in this particular case. Likewise, through the victim PW6, though the victim PW6 have disclosed about the instance of 2008, as discussed above regarding involvement of Deepak Mahanta, the present petitioner, vis-a-vis his previous threatening so as to create the base of criminal conspiracy. But on being confronted, the IO, that is PW14, has considered that the witness has not disclosed the same before him in his statement. As such, I do agree with the contention of the learned defense counsel that same cannot be treated as free from exaggeration. Resultantly, prosecution has, this is important, my lord. Resultantly, prosecution has not succeeded in this case to establish any criminal conspiracy between the present accused persons with the accused Subhasis Sahani and Deepak Mahanta. Deepak Mahanta is the present petitioner, my lord. Thus, prosecution has not successfully brought home the charge under section 120B of IPC against the accused persons. So, this is in view of this clear finding of the learned trial court in while my lord conducting the trial in respect of the men accused who had
that you can point out to the trial court now. Same judgment you read out before the trial court.
After this finding, my lord, what remains, my lord?
That's what, nothing remains. You've pointed out.
My lord, again, I will have to face a trial unless only the court below will be, my lord, burdened with my lord, proceeding with a trial, my lord.
No, don't worry about it. You don't worry about the court, sir. You don't worry about the court.
Finding which has come, my lord, which has come on taking evidence. He has already found that there is no conspiracy so far as the present petitioner is concerned, my lord.
All right. Permitting the petitioner to raise all, please, the professor. All right.
One pardon, my lord. Item 80, your lordship detected all the petitioner residing at Kolkata. Instead of that, petitioner number 1, 2, 3 at Sundargarh, petitioner number 4 is Andhra Pradesh. That
you told me Calcutta, so we
no. Calcutta, cause of action, your lordship detected correctly. Cause of action is at Kolkata. At present, petitioner number 1 is residing at Sundargarh. 4 is at Andhra Pradesh. That clarification.
All right.
Item 80.